Good afternoon, everyone, and welcome to the Alternative Dispute Resolution Certification Working Group. And I'll just remind everybody that the meeting is being recorded. Angela, would you please take the roll?
Armstrong, Coulter,
Here.
Jenkins,
Yes.
Curtis,
Here.
Dubois is absent, Ellis, Jenna
Here.
Ellis, Dr. Getz,
Here.
Taguchi, Hodgson,
Here.
Jones is absent, Kelly,
Here.
Kopaken,
Here.
Bruce,
Here.
Lowe, Judge Lucky.
Here.
Here.
Thank you both. Judge Pishon,
Here.
Walewski,
Here.
Robertson is absent, Tuckman,
Here.
Welch,
Here.
Yamshon.
Here.
You have a quorum.
Thank you. Next on the agenda is the call for public comment. State Bar staff will attempt to call members of the public in the order they appear in the attendee pool. Angela, would you please provide the instructions?
Yes, for those who are participating by Zoom, please use the raise hand icon at the bottom center of your screen. State Bar staff will call on you in the order that your hands are raised. If you're calling on the telephone, you may virtually raise your hand by pressing the star key and number 9. Each speaker will have 3 minutes, and the on-screen timer will begin as soon as you start your comment. 30 seconds remaining. When there are 30 seconds remaining, via flash. We do have one advanced sign up from Kevin Levian. Kevin, if you're in the attendee pool, please raise your hand. I don't see him. Is there anybody else who would like to give a public comment? Please raise your hand. Okay, we have Noah Stein. Noah, your mic has been unmuted.
Thank you. So I just want to share, I had not originally intended to speak today, because I think I've already spoken enough, or I felt I had already spoken enough. But since I feel like this is likely the last chance before Section B is discussed, I figured hopefully there would be no harm in just reiterating my concerns. The one thing that I want to say before I start is that I really gained an appreciation in listening to Monday's meeting, particularly in the discussion around Section M and the discussion of who is really inside of this, who is covered by this and who is not. And that discussion made a big impression on me, in addition to seeing how much time and effort the committee has clearly made towards this. And so the only thing that I want to add, which is not new, which is that in Section B, the removal of the 2-hour minimum creates the possibility to really make the profession of mediation something bigger than what it currently is now. I think for the most part, mediation is settlement conference. And yes, it's true that people can hang up a shingle and develop a private mediation practice, but being able to use the courtroom mediations as a stepping stone in their training and in their certification, I think is pivotal in making mediation the robust profession that I think that it wants to be. And I understand that so much is hanging on this committee in terms of getting so much done and being required to fulfill the obligations of the law and trying to find the way to fulfill the law in the way with greatest fidelity. And I understand that. And I believe it's not mutually exclusive of making this change that makes the profession more durable, robust, lasting, and also satisfying. And I I have no idea what the final decision is in store today, but I hope that that change will be made. And many, many others are standing behind me and feel the same way. Thank you so much.
Thank you very much for your comments, Mr. Stein. Angela,
Heather,
are there any other members of the public who wish to speak?
I do not see anyone right.
Thank you. Now we'll move on to the approval of the minutes from the last meeting, and that is the meeting that was on Monday, June 1st, 2026. Are there any corrections or modifications to the open session minutes? If none, may I have a motion and a second to approve the minutes?
I'll move they be approved as mailed to us by staff today.
And I second it. Dana Curtis.
Okay, who is the mover? Mr. Yamshan? Yes, okay.
Mr.
Mr.
I thought
Kelly.
it was Mr. Kelly.
Oh, I'm sorry, Mr. Kelly, sorry. Angela, would you please call the roll?
Armstrong, Coulter,
Yes.
Curtis,
Yes.
Lincoln,
Abstain.
Dubrow is absent. Ellis,
Yes.
Dr. Getz,
Yes.
Taguchi, Hodgson,
Yes.
Jones is absent. Kelly,
Yes.
Kopaken, Kopaken,
Yes, sorry, my microphone was acting.
Bruce,
Yes.
Lowe,
Abstain.
Judge Lucky,
Yes.
Gillespie,
Yes.
Robertson is absent. Tuckman,
Yes.
Welch,
Yes.
Yamshan, Yamshan,
You're muted, Mr. Yamshan.
Sorry. Yes.
Judge Pichon. Judge Pichon. Yes. The minutes have been adopted.
Appears to be frozen.
No.
Yes,
Oh,
Thank you. The minutes have been adopted.
can you hear me?
Yes.
Yeah.
Okay, can you hear me now?
yes.
All right, thank you. Next, we'll have the chair's report. And in the essence of saving time, I will not give a report at this time, and I'll move on to the staff report. Ms. Mia Ellis and Mr. Alan Weiner, does the staff have anything to report?
I don't have a report, Judge Bishon.
Nothing at this time, Judge Bishop.
All right, then we'll move on to the business meeting portion. And we began our discussions on Appendix M. We spent quite a bit of time on it, and I want to go ahead and resume our discussions. And I will ask that what was said before not be repeated, but if you want to give a summary of it, that will be just fine. So we'll begin with the discussion on Appendix M. Those are the proposals regarding complaints about State Bar certified practitioners arising from service in court ADR programs. And each of the paragraphs, the number of paragraphs, I am referring to as provisions. And so we will start with the Kopaken-Hodgson proposal and begin with the first paragraph. Would anyone like to be heard? Okay, I'm looking, I'm not seeing hands.
Ms.
I
Hodgson.
see Ms. Hodgson.
Oh, okay, Ms. Hodgson, please go ahead.
I don't want to curtail anyone's comments, but I did want to just let the group know that between Monday's meeting and further review of public comments, Ms. Kopaken and I did go through both our proposal and staff's proposal and came up with some thoughts on how the two could work together. Again, I don't want to circumvent any conversation, any discussion, but I did want to let the group know, and we're happy to kind of go through that once people's opinions have been shared and comments received.
All right, thank you. I'll come back to you then. Ms. Cruz?
Just in reviewing these, I personally was persuaded by the Copaken and Hodgson proposal, and it seemed like in reviewing the public's comments, a lot of other people were too. The one piece that I was concerned about, that was missing was an obligation on the practitioner's part that they need to notify the state bar of these things and really making that a very clear obligation, which I do think the state bar has 100% authority to do, which is some of the concerns I had with other parts of it. So I personally am in support of one, two, and while I cannot see down the screen, I believe the very next one in the state bar staff proposal, yeah, so number one there is that within 7 days, you've got to inform the state bar, and the practitioner also has to inform the state bar of what happens with the outcome of the complaint and just be candid with the state bar about it, and then the state bar can evaluate it. So I personally am going to be voting for kind of one, two, and three, the Hodgson proposal, and then the first part of the state bar proposal. But I'm excited to hear what further compromises may have been made because that may change.
All right, Ms. Cruz, I want to make sure I understand. So in provision number one, where it says the complainant will notify the state bar, um, did you say that that's something you will be voting in favor of, or is it the practitioner?
So certified practitioner will be required to inform the state bar, right? So I agree with the state bar staff proposal, which is number one under there, but I also agree with Jill and Sarah's one and two above. And so that is personally what I wanted to speak on to the group is that I'm excited to vote yes on one, two, and then one again.
Okay. Um, I'm sorry to ask you again, but in paragraph one, it says that the complainant will notify the state bar. So is that what you would you want that to stay there?
And I'm sorry, Judge Pichon, you're breaking up, but one says certified practitioner shall inform the state bar. So no, I don't think it should be on the complainant, and I don't think either proposal asks for the complainant basically um to oh, I see. Um yeah, but they direct their complaints to the court connected program. I think it should be on the practitioner to inform the state bar. So I agree with one, two, and then one again. So kind of one is modified.
Okay. Thank you. That's what I was asking. All right. Yes, Mr. Weiner?
I'm sorry, I just want to make sure that I'm clear now, and I appreciate you raising the question. Um, so, Ms. Cruz, I have highlighted the member's proposal. I've highlighted the last clause of the first paragraph. Are you saying that you think that should be taken out because it should be the duty of the practitioner, not the complainant,
Yeah,
to report?
I don't think that it's the complainants. I think that that is problematic to make the person who's complaining inform the state bar. I think it should be a duty placed on the practitioner.
Thank you for clarifying.
So it's
Okay.
kind of a one, two, three hybrid, I guess, because I'd always thought that that last clause actually meant the practitioner, but Jill and Sarah can correct me if I'm wrong. I thought that they were putting the duty on the complainant to basically address their complaints to court, the court connected complaint process, and then it would be the practitioner who now had a duty. And so, but Jill and Sarah can clarify if I'm mistaken.
Okay. Why don't we ask, since Ms. Kopakin's hand is up, can you clarify what you meant?
You're, you're muted.
Sorry, I've been hitting my unmute and anyway, it doesn't matter. Um, I think this was an iteration. The State Bar staff proposal came out. They provided their proposal after we did ours. Ms. Hodgson and I have talked. Our proposal, one of the proposals, I think this might circumvent a lot of unnecessary roundabouts. We agree that the first paragraph of the staff proposal, we agree with that, do not have an objection to that, and would agree our 1 and 2 and their 1. In fact, I think we would be in favor of changing the language from, it says, the staff's proposal says certified practitioners be required. I think that there should be a shall in front of be required. I do think that the proper onus is on the certified practitioners. I don't have an objection to, an instruction to the complainants that they would also notify the State Bar, but I'm sensitive to what Ms. Cruz just said and would not be opposed to taking that out. And I did not discuss that last part with Ms. Hodgson, so she may feel differently. I kind of like the idea that they're invited to call up the State Bar if they want to, but I agree that the onus should be on the certified practitioner.
Okay, thank you.
Sorry.
Dr. Getz.
Thank you, Judge Prashan, and thank you, members. I have a lot of comments, and I want to try to be brief, but the first thing I want to do is compliment both Jill and Sarah on just trying to work this process through. It takes a lot of fortitude to sort of put something in front of the working group and then be on, sort of to defend it. And I hope that none of my comments really are meant in that regard at all. It's just, I really hope we can get to the point of just understanding that we may need to work with this a little bit more. And I'll tell you why I think that, and I hope we can reflect rather than go to a point of advocacy on this. If I look at the first sentence, certified ADR practitioners participate in court-connected ADR processes that are judicially supervised, satisfy the complaint requirement of Business and Professions Code 6173 as to their participation in court-connected ADR processes. There's a lot in that sentence. And I don't think as a working group member, we ever had a definition of what a court-connected ADR process is, or anything that says what judicially supervised is. And so I'm not quite sure what is meant by those phrases. I mean, I know generally what's meant, but not specifically what I'm supposed to be voting on. So is every court have a judicially supervised complaint requirement, or is there some definition, and who's supposed to judge whether it's judicially supervised or not? Are all court-connected ADR processes everything worth thinking about? I just reflecting back on my work with volunteer DERPA groups, and maybe Mr. Welsh can address this. As I recall, when I was working small claims, volunteering for various DERPA groups, they had a complaint procedure, but it was basically to reach out to the head of the whoever handled it for that DERPA group, which means that's not, I don't think that's judicially supervised. But so then does that mean our DERPA mediators, who, from yesterday's comments, I care about a lot, are they not covered by this? And who makes that determination? So there's that. And then to say it meets the requirement of Business and Professions Code 6173, but part of the requirements of Business and Professions Code 6173, as I understand it, was to be the complaint process to be substantially similar to the California rules of court. So I don't know if a working group would have time, and I know everybody says no more time. We've put a lot into this. I know Jill and Sarah put a lot into this, but don't we have to take a look at that before we say it and vote on it? So I just raise these questions. We might need more working groups. I mean, I certainly think, if the State Bar would consider this at all, I know this is a process, but we might consider a working group on how DERPA mediators fit into the system. I mean, we've heard a lot from Mr. Stein and others, we've this one I have questions about how they fit into the system, and I know we all care about them. So in any event, that's just I don't want to take away from the authors who have thought a lot about this, and I realize there's a lot of time pressure on us to get things done, but I just tell you, my logical questions and looking at even the first sentence, I just don't even know how to get past that. So thank you.
Thank you. Mr. Kelly? You're on mute.
Thank you. I think I made a motion early on in favor of court programs being able to be the ones that handle complaints, and I still am completely in favor of that. They've got a complaint coordinator set up. They've got a whole structure. They've got many of them decades of experience dealing with this stuff. So I would like to work this out. I think the state bar has a floor that the statute sets that whatever this working group decides has to be met. And looking at the BNP 6173 again this morning, it says the program shall include procedures where the practitioner verifies all of the following. One, the firm provider practitioner requires its mediators to comply with certain ethical standards that are equivalent to the rules of court. We know that's a floor. Two, has procedures in place for persons to make complaints. And three, for mediators, those complaint procedures shall be substantially similar to the complaint procedures specified in the rules of court right after those ethical standards. I think that sets a floor that the practitioner has to be able to verify as I read the law. And the state bar is required to have standards where the program includes something where the practitioner verifies all of those. If I'm a practitioner on Sarah's panel, I'm pretty confident I can say, yep, my complaint procedures comply because I'm going to be using the rules of court. That's what state courts are required to do. So I can verify as a practitioner, yep, my complaint procedures are substantially similar to the California rules of court. In fact, they're identical. If I'm on a federal court panel, how will I as a practitioner verify, and I read that that's my requirement under the law the way I read it, that the complaint procedures are substantially similar? Doesn't say identical, says substantially similar. Who judges that? Do I as practitioner judge that? Does the state bar judge that? I think there's a statutory floor set under this that we need to pay attention to, and I'm wholly in favor of Ms. Kopeikin and Ms. Hodgson and staff working to something they can all live with. Thank you.
Thank you. Mr. Welch?
Yes, thank you all very much. And thank you, Dr. Getz, for mentioning me in this space, and also just to have the considerations for ancillary court kind of connected programs that aren't directly under the court's supervision, right? That would be those that are the contractors, the DERPA funded organizations, nonprofits, court referred programs, court approved programs, or similar public service mediation programs. And to deal with the space of how those complaints work is definitely an important one for us to figure out, because we do not want to bypass the obligation of our accountability that needs to be had for the services that we provide. In that particular context, they are not the same judicially supervised complaints, right? Because we are not a part of the court's official, panel for those services. So then the question becomes, well, what does that look like? Most of these court programs, I would imagine throughout the state, would be those that have MOUs/relationships with the court. Have the DERPA funded programs have administrators that we have to respond to for our complaint system. And then there also is the potential court that we would need to provide information for. The question of need is, well, is that truly an obligation? Is that something that's a need, or is that something that's required, or is that something that's just suggested? And in this process, it would be one for any organization that's in this space to have some clarity, to say that potentially that an administrative program could have, if there is a complaint, that it first is by the program, that there is an obligation that at the end, that if there was a serious ethical violation, that it is then something that is, because you have the program, you have the dispute resolution program administrator, you have the court that you would have to report to, and that you'd then have the eventually the state bar. And so it has a lot of components, but I am in favor of what this looks like from the court's perspective of how the judicially satisfied. I understand what that means because it's separate from the ancillary programs, but it could be confusing to the public, exactly who's, responsible and where. So I don't want to bifurcate that. I just want to show that there's a lot of nuance in the space, but there are ways that we can, try to work there. The main piece for any organization in here is the one where multiple complaints could be filed in multiple places. Okay, what's the pathway? What is the where should we go in the pathway of a complaint to be filed? And the secondary part is, how does that affect a certified mediator coming into our organization? And then, how do we treat them? How is it treated? What is our obligations as a volunteer, as a certified mediator coming into a program? Where would that land as far as our obligations as an organization to handle those complaints and move forward? So clarity is of utmost importance and understanding for that.
Thank you. Ms. Kopakin, I saw your hand, but I don't see it now. Did you?
I would love everybody else to have a chance to talk. I had some
Okay.
thoughts in response to Mr. Kelly's, but I think we're talking about really important things. Thank you, Mr. Welch. I
Okay,
don't know
wait,
enough about
wait, Miss
ARPA.
Kopakin, if
Mhm.
if you wanted to give everybody else a chance to talk first and then come in, then I saw one more hand. I'm
Mr.
sorry about my internet. I saw one more hand and then I'll take yours, okay? Mr. Weiner?
Yeah. So, first of all, I'm appreciative that Ms. Kopaken and Ms. Hodgson are still trying to find common ground, and certainly it's meaningful that they're agreeing to the first paragraph of the staff proposal. I also want to underscore what Mr. Kelly and what Dr. Getz said about some lack of clarity. I understand that in the second paragraph of the Hodgson Kopaken proposal, they have tried to identify or try to define court-connected ADR processes that are judicially supervised. But I think a few problems with that have been raised. Mr. Welch raises the question of what does that mean in the DERPA context. Dr. Getz has asked, well, who makes that determination? I also agree with Mr. Kelly that the statute sets the floor for the ethics standards and for the complaint process, that the ethics standards need to be substantially similar to, and the complaint process needs to be equivalent to. I just want to highlight that doesn't set the ceiling. Statute says that the program shall include but not be limited to those things. So I think the state bar has the prerogative to have additional requirements in the interest of public protection. So with that sort of general background, I'm hoping that members will consider both the Ms. Kopaken and Ms. Hodgson's proposal and the staff proposals alongside each other as it has begun to do. And I just want to give, there's sort of a lot of words in the 5 paragraphs of the staff proposal, but I've kind of boiled those down to what I think the gist of these 5 paragraphs is. The first, which has already been discussed, is that the practitioner is required to report to the state bar if there's a complaint in a court process. And I think that's been accepted. The second, and this is something that Ms. Cruz raised, the second staff proposal was that if the complainant comes to the state bar, the complainant should be encouraged to report to the court and told the court has a process for you. And I would differ from Ms. Cruz in this regard. I think the complainant should also be encouraged to come back and tell the state bar what happened, because we don't know that the practitioner would do that. We know that the practitioner should. And if they're encouraged to do it, I don't think that's too heavy-handed. The third short version of paragraph 3 of the staff proposal said that the state bar may defer consideration while the court is doing it. I think staff would be in agreement with changing the state bar may defer to the state bar should defer, unless that would interfere with the state bar's public protection function. And the fourth is that the state bar can consider information provided by the court as to, what they decided. It doesn't say the courts have to provide information about their complaint process, but the state bar is going to have this certified mediator hanging out there, and the state bar is going to know there's a complaint about it. Does that mediator stay certified? You don't want to have a duplicate process. So how does the state bar determine what to do? And the fifth one, which received a lot, maybe the highest negative comment of the group, was whether legislative changes should be sought that would allow courts to report to the state bar. And the reason for that was that in the discussions with Ms. Kopeikin and Ms. Hodgson, they questioned whether or not the courts had the authority to do that. So this was really an attempt to address a concern that they raised. So it's all of those points, I would say, are compatible with the notion that the courts should be the primary body to hear complaints that emanate from a court ADR program. Thank you.
Okay. Thank you, Mr. Weiner, and I appreciate the fact that you've gone through all 5 of the provisions. And so I'll let everybody know that you're welcome to now give your comments on any of the 5 provisions here. And then I'll hear from Ms. Kopeikin and Ms. Hodgson about what changes that they think can be made. So Ms. Curtis, if you want to respond on any of the 5 provisions, you're welcome to do so, and everybody else is also welcome. Ms. Curtis?
No, I was responding to the issue of DERPA mediators, not the ones that, so I can do that later.
Okay. We will come to that when we get to the next appendix, Appendix B.
Thank you.
Thank you. All right, so it's open now for discussion on any of the 5 provisions. Ms. Kopeikin, do you want to give your comments now?
Sure, I can, if nobody else has additional questions or thoughts. So part of what we tried to do is, Mr. Pulaski, I see a hand up.
It was just a question, and I'm sure you can answer it for me, Jill. In the second line of paragraph 1, it says, complainants for court-connected ADR processes should be directed to raise complaints by who? Who is going to be doing the directing of them?
The state bar, but I think that when we're adopting staff's proposal in paragraph 1, I think that clarifies some of those issues.
Right, I agree.
Yeah.
Okay.
Yeah, thank you. Yeah, so I mean, what we tried to do is address some of the issues that Mr. Kelly raised about, for example, there being, the statute being the floor and the lack of clarity. We agree that the statute sets the floor for what the certified participants, in this case, certified practitioners, would be doing. And what we are trying to acknowledge is that the court programs that have established complaint procedures that follow, that either in the state courts that explicitly follow the California rules of court, and in the federal courts, we have a program that one could argue whether it is substantially similar, and I don't want there to be confusion about that. It does have a formalized confidential complaint process that is supervised by a judicial officer. If the complaints go to a formal process, it actually would go to a noticed, a hearing where the people have an opportunity to be heard. It's all sealed. It's kept in a sealed record, separate from, the public docket. So that's not identical to the California Rules of Court. We don't have a complaint committee. So I think it needs to be clear that whether, for a certified practitioner, if they are compliant, if they're in our program. And, this program has been operating for 35 years. I am unaware of any complaint that has led to an ethical complaint that has resulted in a state bar issue or any formal censure of a mediator for ethics, so an ethics violation. So I think it is largely a very small, I'm not saying it will never happen, could happen, but it's a very small number of potential issues, but a big opportunity for lack of clarity. So clarity is really important. So what we tried to do is say, you will be complying, practitioner, if you follow this process. I am all in favor of the state bar's proposal, paragraph 1, because I think it does help with that clarity. So thank you for that. We have some, tweaks that we could talk about for the first paragraph of ours, and we talked about maybe moving the definitional portion up above for exactly the reasons that you all are talking about, just in terms of clarity about what exactly are we talking about here. I don't know enough, and I'm sorry about that, Chris and others, about the DARPA programs to say whether they are judicially supervised or if there's a judicially supervised process. That's something that I can't speak to. But where there is, a complaint process that is either identical to the CRC or there's a specific judicial officer who is policing, compliance, I think that should be beyond meet the floor. And so that's what we were trying to identify. So then going down, I'll just continue through the paragraph numbers, I guess, staff's paragraph 2. And if you want to move down to it, I'll just kind of read through. So on that one, what we would suggest is that that lengthy first clause all looks good. Then it goes to the state bar should. We would ask that it be changed from should ask to shall instruct. Right. I'm putting my cursor on it. So after the
You're
first.
saying should
Nope, sorry.
instruct the person
above.
making?
No, above. Yes, there.
Should instruct.
We think it should say shall instruct. Let's just make things very clear about who has what obligations. And then, yeah. And then eliminating
Yeah, well,
whether
this is,
they.
excuse me if I can just interrupt. So the rest of this sentence, if I modified it where you want, it says the state bar shall instruct the person whether they have reported the concern. That was why.
Continuing on to whether, actually, I would change that. Okay. And then cut out whether they have. And it should say to report their concern. And then after the court, I would just put a period. And I agree with Mr. Weiner. I think it is, when you're requesting that a complainant, I'm sympathetic to the issue Ms. Cruz raised, which is we don't want to put undue burden on the public. But I do think that encouraging them to do that, it gives the opportunity of the state bar having greater visibility without improperly burdening them. So that's what we would propose to meet the state bar's concern about keeping the state bar in the loop. And other than that, I think, unless Ms. Hodgson has additional comments, I think we would agree with 2. Moving on to 3. First clause all looks good after the state bar, after that first comma. Again, I would say shall defer. And then going all the way down to if you go down, it would say shall defer the investigation and resolution of the inquiry or complaint pending investigation and resolution, it's a lot of words, of the inquiry or complaint by, and there I would say the court, because we've already said that they're sending it to an court that has a procedure, and then I would put a period there. I'm not
So
trying
you would
to,
put a period here?
yes, and then delete to the end of the sentence and to after court. Yeah. This will acknowledge that not all courts follow processes that are identical to California Rules of Court 3.865, but if they don't have a process that's identical, they have to at least have some judicially supervised process. Going on to the next paragraph, after the second comma, so I think that's the easiest way to orient you. Hang on. Wait, I might have gotten, I think I've gotten lost. Hang on. No, that's correct. No, my apologies. After if a court, we would say, if a court, comma, certified practitioner, and I think you've been capitalizing certified, or sometimes it is, sometimes it isn't, but we might want to clarify, just for consistency's sake, or a complainant. In other words, if any of these people inform the state bar of something. Okay, then going down to the taken, excuse me, the first taken, so directly underneath where the last edit is. Again, yeah, so after that, I would put in by a court. Concerning a complaint against a certified practitioner. And delete to the end of the sentence. Or the end of the clause, excuse me, not the end of the sentence.
You're taking out under a rule of
Yes.
Court 3.0.
Because in my mind, that restricts things that don't need to be restricted. Again, that's the floor, it's not the ceiling. And thank you for doing this, Alan. I appreciate it. It's hard to follow along. And then was taken. And then after was taken, we would cut out that clause. So that starting with and or and ending with status. Delete that and that. Also that comma, and then the balance looks fine. If you want me to explain in that one, it suggests the courts do not typically, and I think would be uncomfortable with an obligation to make a recommendation to the state bar. They might be reporting facts about, somebody has been found in violation of X, Y, and Z, but I don't believe that it's their role to tell the state bar what to do in terms of censure. And so our thinking was that the facts might be something that would be delivered, and then it's in the state bar's discretion on what to do. And we thought that makes it clearer. And then the final paragraph, we don't understand. Sarah probably can speak better to this. She's a general counsel type. I'm not. So I can just, I think I'll just turn the floor over to her if that's all right.
Judge Pichon, I'm happy to cover item 5 with your permission. I know I didn't have my hand raised.
Let me just see. I would assume you're saying that the state bar doesn't necessarily have to follow through and try to make things different by contacting the legislature, and it may be very difficult to do that in any event. Let me just ask Mr. Weiner and Ms. Mia Alice, is that something that you feel very strongly about including number 5?
So this really, if I may, this emanates from the discussion, one of the many off the record discussions we had with Ms. Kopeikin, not off the record, but outside of the working group with Ms. Kopeikin and with Ms. Hodgson. The question was there were concerns that the court may be constrained in what it tells the state bar. And so it seemed that there was an agreement at that time that it would be helpful to have a clarification of the rules of court or the statute saying that the court could provide this information to the state bar. So it was really aimed to address an obstacle that came up in the discussions. I don't know if I don't know that it's critical. I don't think that the state bar needs to have a working group recommendation to review a statutory amendment, but this also refers to the rules of court, and Ms. Hodgson has a line in with the rule of court amendment process. So if she thought this would be helpful, the Judicial Council would probably be moved more by having the state bar say this would be helpful than just having it come from staff. So that was the thought behind it.
Okay, thank you. All right, Ms. Hodgson, what was going to be your suggestion? Not, yeah, can you put it in a nutshell what your suggestion was going to be for provision 5?
Absolutely. Mr. Weiner is correct that number 5 really came out of addressing concerns that Ms. Kopeikkinen had regarding the restrictions that the law currently exists. As he stated, I don't know that there needs to be a working group recommendation or itemization. It made sense for purposes of the public comment to address that concern, but for purposes of how we move forward, I don't know that it needs to be in writing or an instruction to the state bar. And frankly, if I were the state bar, I would not love that. They can certainly do what they want as far as seeking amendments to the statute, seeking amendments to the rules of court, and the courts, as we must do, will comply with whatever the law is that exists at the time. If there is a strong sentiment that some language needs to be there, I had worked with Ms. Kopeikin, and the language we thought was to say if there are amendments to the relevant law that alter courts' requirements or ability to report information about such complaints, the courts shall comply with the law as it exists at the time the complaint is filed. That also protects folks who, filed a complaint way back when in 2020 or 2021 when the confidentiality rules were what they were as currently enumerated, and aren't surprised years later if there is an amendment that says, surprise, everything is unveiled to the state bar. So that was our suggestion, if there's a strong feeling that there needs to be anything there at all.
Okay.
Well, Ms. Hodgson, sorry if I may, if you could put that in the chat, then I will copy it into this document. And if I could go back and just ask a question of Ms. Kopeikin and
Okay,
Ms.
so
Hodgson.
Mr. Weiner, before you go on, I just want to know if staff feels strongly about number 5, then I believe Ms. Hodgson should go ahead and put the comments that she made in chat. But if not, I can go to the group and see how they feel about including provision 5.
I think we don't think it's necessary if I'm.
Okay.
I agree. I don't think it's necessary.
Okay.
So we could take that.
Very good. So we'll
I
take.
did want to.
Go ahead.
I just wanted to ask, I'm really grateful for the further consideration that Ms. Kopeikin and Ms. Hodgson have given to this. There's one word that I would like to ask whether they would be amenable to changing this shall here to a should. It's already qualified in the next sentence if the state bar determines that deferring would unduly interfere with its public protection function. So there's already sort of kind of an exception written into the next sentence. So the should, I think, would be a better fit in that context. I see Ms. Hodgson's hand.
Ms. Hodgson?
There was one modification actually to that sentence however, that I think in our excitement we forgot. the proposed edit that Ms. Kopeikin and I had discussed in that however sentence is, however, if the state bar determines that deferring will unduly impede its duty to protect the public from misconduct by the certified practitioner, it may decide not to defer action. And that was the other suggestion that we had, is to just kind of give that permissiveness and that's tempering the shall, right? The default would be defer the action, but if there's something so egregious that you think the duty to protect the public would be undermined, then the state bar may determine it needs to move forward. And we did also want to suggest the possibility at the very end of paragraph 3 of saying, in that event, the state bar should notify the applicable court of its non-deferral, so that the state court or the federal court is aware that the certified mediator may at that time be being subjected to concurrent complaint processes. We're not looking to get in the state bar's business. We're not looking to have information about the outcome of the complaint, just awareness that that is happening.
So to think that the state bar shall notify the court that it has elected not to defer. I'm trying to use your language as
Of
exactly.
its non-deferral, but your language also works there.
And my audio clicked out a little bit when you were giving this language here. Did I capture what you intended to insert here? Well, unduly, well, I can see it doesn't make sense. Your however sentence, could you read your edit to me again, please?
Yeah, I think the only change that we suggest in that sentence that starts with however, if the state bar determines, is to change the should not phrase to may decide not to.
So you were not adding.
No. The state bar may decide not to.
So with these suggestions, do you have any openness to the idea, since the shall defer is qualified, to changing that to a should?
I
It
would
just seems,
appreciate hearing staff's perspective why the shall would be more helpful as a should, because if it's already tempered with that may decide not to.
yeah. So my perspective on it is that it potentially puts the state bar in a conviction, position of having conflicting instructions or duties. One is it shall defer, and the other is however, which sort of qualifies the shall, as you've said. It just seems more consistent with the however clause to say should than shall.
If there's a shall, that is mandatory. And then you cannot take it back in that last sentence.
What if we put a notwithstanding instead of however?
Where's the however?
Notwithstanding the foregoing.
They conflict with each other.
You can say unless. So shall defer unless the state bar determines that deferring will unduly impede its duty.
In which case the state bar may decide. I would be amenable to that. Thank you, Ms. Cruz. And I'm speaking for myself on that amenability. I won't speak on behalf of Ms. Kopeikin.
I was going to suggest something very similar. Thank you, Ms. Cruz.
All right. Other comments? Okay, I'm looking. I don't see hands. Okay, so going back up to the very first paragraph.
Madam Chair?
Yes. Oh, Mr. Kelly, is your hand up? I'm sorry.
Yes.
Please go ahead.
If you go back, Mr. Weiner, to that paragraph there. The proposal is to take out the language that says a complaint procedure that's substantially similar to that set forth in the rule of court 3.865, et sequitur. As I mentioned before, as I read the statute, if I want to be certified, it's on me as a practitioner to verify that I have a complaint procedure that complies with that rule of court. I don't know that changing this paragraph relieves me as a practitioner, if I want to be a certified mediator, of verifying that I have such a complaint procedure that's substantially similar to those in the rules of court. And I think the state bar is required by statute to say that's one of the requirements it has to have as I read the BNP code. So I just want to note that it's still on the practitioner to have some clarity when they're saying, yes, state bar, I verify the following, whether or not whatever their complaint procedure is substantially similar to the rules of court, I think. Thank you.
Okay, Mr. Kelly, that is what I was going to, I'm, trying to not say anything, but that is what I was going to point out, that the statute does require compliance with the rule of court 3.865. The state courts have to comply with that. According to the statute, and when we finish, the provider organizations and the providers and the practitioners will all have to comply with it. It's just going to leave out one segment. Everybody else will have something that complies with the rule of court or is substantially similar. So you're making an exception for one set of one court. And is that what we want to do? If that's what we want to do, we need to spell it out. But we can't write something that now nobody will understand what to do. And Mr. Kelly refers to that as the floor. That is the floor. And this is just carving out, which I don't know which court it is, but it's just carving out one set of courts. Everybody else will have to comply.
And if I just make one more point, the clarity is necessary for an applicant. If I'm applying, I've got to verify this, whatever my complaint procedure is, whoever it's through. As I read the statute, the floor requires this of the applicant, of the practitioner, to verify that they've complied, that their complaint procedure complies with that. And I'd like to have clarity for any applicant. Thank you.
Mr. Weiner, can you go up to the first paragraph, please?
The first paragraph of the member's proposal.
The very first provision, I'm sorry. So if you
Yes.
have compliance with judicially supervised, that's not the same as the rule of court. So the group has to be careful that we're consistent throughout and we've treated everybody the same. Okay, I'm done. Other comments? Help me out if anybody has a hand up that I don't see.
There are several.
Yes, I've had my.
Oh, okay, wait. Let's see, why
Dr.
don't
Ms.
Getz.
Kopeikin, Dr. Getz, and Ms. Curtis.
Dr. Getz, I'm sorry, I can't see any hands. Dr. Getz?
Thank you. Going back up to paragraph 1, I would love to hear from the authors. Yes, please. Thank you. Again, I'm not sure I got the answer to the question. How do we know if something is if a process is judicially supervised? Who makes that determination? Is there a committee? Every court I mean, there's different courts maybe not represented here, and I know you're not represented as a court. So I just wonder if we need to establish a process of how that, right? And also, Mr. Welsh did a lot in laying out, hey, there's contractors in the court, there's all sorts of things. How do we have any definition of what's court connected? Because in paragraph 2 we go court connected ADR process or judicially supervised. All ADR process facilitated by neutrals who are recommended selected. Again, I see it, and I still don't know the practical application of all that and who makes that determination. If you have any thoughts on that, that would be really helpful.
Mr. Weiner, would you help me with the hands? Because I can't see them.
Yeah, so I see Ms. Kopeikin and Ms. Curtis
And Mr.
and
Yamshan.
Mr. Yamshan
I'll defer.
and myself.
With your permission, I'll defer and go after the balance of those folks.
So Ms. Curtis is next in line, if you will.
Thank you.
Yes, I wanted to get back to this question of DERPA, and as I just listened to Dr. Getz, I think that maybe there's a way to move forward because I think there needs to be clarity about whether DERPA programs can administer their own complaint procedures. And I wonder if and this is a question for you, Jill and Sarah, did you intend that the judicial supervision be over the complaint process or just more generally? Because if what you're saying is that the complaint process needs to be judicially supervised, that narrows the field, it seems to me. I don't. Anyway, and as to the DERPA programs, I think that we didn't really spend a lot of time on this, or maybe any time on this when we were discussing this issue before. And I wonder if it's because the same issues, the same kind of potential conflicts as really what we were talking about as federal court, because state courts, as has been observed, are covered by the same provisions. But, so having, conflicting jurisdictional issues and so forth. So anyway, that's my comment. I hope we can clarify it, and I would suggest that that not, sort of confusing things by implying that DERPA programs can handle complaint procedures for their own panelists. I think that's probably not the best idea. Thank you.
So, Judge Bashan, I think Ms. Kopeikin is still deferring, if I understand correctly, as I will.
Okay.
And we'll maybe call on Mr. Yamshan necessarily next, and then maybe come back to Ms. Kopeikin and
All right.
me.
Mr. Yamshan?
Thank you. I love the Freudian slip, Mr. Weiner, where you almost said we'll call on Mr. Yamshan unnecessarily, but it's all right.
Did I say that?
Almost. You were close. Mr. Getz, I'm wondering if we can't clarify court connected fairly easily, which would mean referred by a judge or a court clerk. And that I think would cover pretty much everything in the federal system. Some of the district courts have early neutral evaluation, which would be the clerk would handle that. With court-connected arbitration in the superior courts, the clerk will assign a case to an arbitrator. The arbitrator will contact the counsel, so on and so forth. But at its most abstract, I think the effect is the same, that an institution, the courts, are referring out a dispute to an alternative system, whether it's mediation, whether it's arbitration, by a practitioner other than a judicial officer. That's all.
Ms. Kopeikin, if you'll allow me to go next, I think I may have a solution to all the angels dancing on the head of a pin here. What is a judicially supervised program here? And what I'm wondering is, if we have the agreed language, revised language about complaints that violated an applicable ethical standard while serving in a court ADR program, the state bar will defer to the court. Do we really need the first two paragraphs of the member's proposal, or have we really addressed your key concern, which is that the state bar defers to the court, and that would bring us to Mr. Kelly's concern about whether the process complies. I'm just not sure it's necessary to define what is a court program mediation, really. A rule of court 3.851, no, yeah, 851, I think it is, goes on for 3 paragraphs in defining what is a court-connected, when a mediator is obligated to follow the ethical standards in Rule 3.850. And there's just a lot of nuances about, referred, selected. What if the person is on a list and they're selected, outside of the court program? If we can avoid trying to define something doesn't need to be defined, I think that may be beneficial. And I really intended that to Ms. Kopeikin and Ms. Hodgson about whether the staff proposal as modified, per your suggestions, would solve that problem.
As modified so let me just ask a question. Is it this working group's intention to exclude the federal court programs from what we're talking about? Because that's what I'm beginning to think is the objective. I don't read the statute to say that the complaint process that needs to be identical to the rule, or needs to be what the rule of court establishes, as I heard the chair, Ms. Pichon, Judge Pichon, saying. It says substantially similar to, and as we've discussed at some length, there is not a great deal of clarity about precisely what that means. We tried very hard and the reason that we put in the definitions and the first 2 paragraphs was because we were trying to say, we agree it shouldn't be any kind of, when you have a referral to, a list that maybe isn't supervised, but the court lets people sign up, but there's no supervision from the court. That's a really different thing from the situation where you have, and I thought we were clear when we said, in the language we proposed, and I'll just drop it into a chat. I thought it was pretty clear that the participants who in the court panels would be subject to a confidential complaint process supervised by a judicial officer that may address ethical violations and impose remedies. I thought that was pretty clear. I think that's substantially similar to, but it is not identical. I will concede it is not identical to the California Rules of Court. If it is this governing body or this, working group's intention to specifically say that the federal courts, because they are not identical to the California Rules of Court, could never be covered by this, then we should just say that explicitly rather than trying to do an end run that means we can't comply. We have a federal magistrate judge who hears every one of our mediators is appointed by the court. By local rule, they are serving in a quasi-judicial capacity. They are supervised every single case. Surveys go out to every single participant. Every single survey that comes back with any kind of negative comment is followed up with by our unit. And then any complaint that somebody files is subject to a noticed hearing where that is handled confidentially on the record by a sitting judge. If that doesn't comply, and this group intends for this not to meet the requirements, then I'd like to know that directly so I can advise my panel members. I thought we were working to something that recognized that it's not identical, but we have a process, and that's what we were trying to address, which is there may be different ways, but there is a minimum, and it has to have, I know in the state courts you have the complaint committees, That's a valid way to do it. This is another valid way to do it. But if what you're saying is it's not in compliance with the statute, and no, then I don't know what I've been working so hard to try and have. And maybe I was just misunderstanding the target here, that we were trying to make something that would work for, you know, our panelists too. But maybe I'm mistaken on that. So I'll ask that question.
Ms. Kopagan, there is what you have said, there's no question about whether or not the federal courts are in compliance. It's just somebody needs to be able to determine it.
Okay.
If that person or entity is the practitioner just needs to know what the program consists of. That's
Okay.
all.
Fantastic. Thank you for clarifying. I appreciate that. I think that was why Ms. Hodgson and I worked so hard to try and differentiate between programs that might not meet that minimum, those standards, and which is why we put in the language. Thank you, Mr. Weiner, for, well, you had it highlighted there, but where we had, you know, about the you know, what we defined. And I think, to answer your question, that was a long-winded way of going back to, should we just cut out paragraphs 1 and 2? And I think the answer to that is no, because I think we do need to give notice to both the certified practitioners and to the consuming public as to who is the right entity to handle complaints. And also, is the certified practitioner complying if they have deferred it to, for example, the judges that sit in my court? And that's why I think we need those provisions, although we could probably continue to refine them. And there are a lot of really smart people here. So let's talk about how we do that so that, you know, that there is that level of clarity.
If I may.
Yes, Mr. Weiner.
Just a suggestion that might help with this. So Mr. Kelly raised a concern about taking out the language from staff 3 as modified that would take out that follows a complaint procedure that is substantially similar to. I wonder if a compromise might be to say that follows a complaint procedure that complies with section 6173. So it doesn't, I mean, it leaves maybe a little bit more latitude. Honestly, I think in substance, it may not make that much of a difference, but it may at least frame the issue that what needs to be determined is whether this complaint procedure complies with 6173. You know, I also want to say, Ms. Kopagan, that from staff's perspective, you know, we've been working very hard with you to come up with something that fits for the federal programs as well as the state program. So, you know, I hope you're not thinking that, well, I hope you'll reconsider your view that folks may be trying to exclude your program. I'd also note that you know, when we were talking, you provided staff with the central district rules, which almost seem to be modeled after Rule 3.865 and that procedure. And just suggesting, not telling any court that they need to modify the way they handle complaints, but a court could decide that for purposes of handling complaints about state bar certified mediators in a manner that's consistent with section 6173, they would follow a procedure like in the central district or like in Rule 3.865.
All right, so Mr. Weiner, you're asking if the language that has been stricken, say in paragraph number 3 of the staff's proposal, is substantially similar to that set forth, is that, or complies with. Do you want, would it be your suggestion that I go to the group and see if that language is okay, or if they would like that language stricken?
Yeah, well, I mean, I think there are several options. One is to keep in the language that is substantially similar to the set forth in 3.865, which is the statutory language. A softer way of saying it may be one that complies with 6173.
Okay, that's fine. Let me ask Ms. Kopagan and Ms. Hodgson how they feel about that. inserting the language complies with section 6173 rather than is substantially similar to that set forth in Rule of Court 3.865 at sequence.
Speaking on behalf of myself, I appreciate staff's attempt to find alternate language, but it seems to me that it's a bit of a matter of semantics. And one of the things that I recognize this group talked about or tried to talk about initially, and that led Ms. Kopeikin and I to come up with the definition that we did and the proposal that we did, was earlier on this idea that no one was able to answer what was substantially compliant with their rule of court. No one was able to specifically say, yes, the federal court program, despite all the documentation that Ms. Kopeikin provided, no one was able to definitively say, yes, that would check the box. Yes, that would meet that. So we tried to come up with the definition that we did to create a framework, to Mr. Kelly's point, to give applicants that clarity of, yes, the program I'm participating in does comply with 6173, does comply with the rules of court. And so I would not be subject to context. So that was our intent and our interest. So I think I remain a bit uncomfortable even with the complies with section 6173, but am amenable to continue to try to better define and clarify what would match the statute and what would give applicants clarity in a way that is inclusive of court programs without infringing or interfering on their jurisdiction to have their complaint procedures as their relevant legal authority requires.
Okay, thank you. Is there another hand up?
Mr. Pileski's hand is up.
Mr. Pileski?
I have a simple question and then a point to make. One, I'm not familiar with what the remedies may be in any of the court programs. Just so I'm clear, I know the state bar can basically take away your certification, and that's pretty much it, I think. Are there any other remedies in the courts other than to throw people off the panel that we're really talking about?
I'd be happy to answer that.
Oh, please.
Sarah Hodson. In case you want to take a look, Mr. Pileski, Rule of Court 3.870 identifies for state courts the permissible court actions on complaints, and it ranges anywhere from direct that no action be taken on the complaint to remove the mediator from the panel. It also includes the possibility to counsel, admonish, or reprimand the mediator, to impose additional training requirements as a condition to their continuation on the court's panel, or to suspend them for a period of time.
From the panel.
Yes.
Right. And the only other question, let me just get this out, that the word defer has different meanings, and I don't know whether it's something we should address or clarify. It can mean put off, just delay. Mm-hmm. But in the labor law context, where are you deferring to an arbitration panel's decision? Are you suggesting that the deferral here means wait until they're done, or that you should be bound by it in some way to some degree? Anyone can.
Yeah, if I address that as one of the authors of this provision in the staff proposal, the idea was wait and see, because the court isn't going to have the authority to remove somebody from certification, to remove somebody's certification. Only the state bar is going to be able to decertify, right? So the court can't, the state bar can't defer to the court in terms of the action to be taken regarding certification status. So it's postponed, and that gets into the provisions where the practitioner, or potentially the court or the complainant are going to report what the outcome of the court process was.
Right. So if the court says no issue here, you still have the ability at the state bar to make your own decision.
I think as the language. So yes, I think that's the case. If court hopefully informs the state bar of the general nature of the violation and the action that they have taken. If the state bar considers it inappropriate for the mediator to remain certified, I think the state bar needs to have the prerogative to take action regarding the certification status.
Thank you.
Okay, Ms. Kopaken, I'm going to call on you. I just want to say I know this is difficult for everyone, but we're going to have to make some decisions. So, Ms. Kopaken, this will be our last round of comments, and then I'm going to have to ask how the working group feels. Ms. Kopaken, please go ahead.
Similarly, we can censure folks. Sanctions can also be issued in the federal system, just answering the last question. And, there's a judge who can issue whatever kind of orders they need to. But the difference is that there's a, on the record proceeding, although confidential, and the judge can and notice and all that. So presumably a judge could also, if they opted to make a report, professional, they can also report folks to the Professional Responsibility Committee, and so there are a lot of tools that sitting judges have to deal with complaints. On the question of whether cutting out the language or having it go back to complies with section 6173, there were parts where Ms. Hodgson cut out her audio. I really want to second and underscore what we did here, though, which is that this was a big portion of what we talked about, and I provided lots of information about the federal program, and specifically was told we can't, that staff was not in a position to say whether it's substantially complied with. So what I was trying with section with the CRC. And so what we tried to do was say, well, then if you can't tell us and we don't know for sure, we should provide some language that gives people clarity. And so that's what we've attempted to do. And I think it is important that the practitioners as well as the consuming public do know. So I would be a strong advocate for saying that it's really important to give that kind of notice. And thank you all for taking so much time. I understand that this is an issue that is largely limited to the federal courts, but our programs have been doing this for a long time, and so I really appreciate the attention. Thank you so much.
Okay, Ms. Kopaken, that clarification is very important. Thank you. All right. So, Mr. Weiner, if you go all the way up to the top. And like I said, working group, I know this is very hard, but I'm going to have to ask you how you feel about the different provisions. And so the first one is the Kopaken-Hodgson proposal, number 1. And I believe we've ended up with the last words, and to inform the state bar of the outcome of the complaint process has been stricken. Is that everybody's understanding that is, we have stricken that?
Yes.
Okay. All right. So I'm going to ask for a show of hands. How many would like to adopt? Not, we won't be adopting, but if there's a consensus regarding adopting paragraph number 1, would you please raise your hand?
So to help with the count, I'll call names if somebody else can use fingers or verify. So I see Ms. Hodgson, Ms. Kopaken, Ms. Curtis, Mr. Welch, Mr. Yamshan, Ms. Cruz, Judge Lucky, Mr. Tuckman, Ms. Lowe, and Ms. Ellis, Ms. Jenna Ellis, and Ms. Coulter. Did I miss anyone? Which would appear to be more than half the people. Yeah.
Okay, it was 11, I believe.
Yeah.
Okay. All right, so for the first one, it's 11. The consensus in favor. For number 2, can I have a show of hands of those who the consensus would be to adopt number 2?
I see Ms. Cruz, Ms. Kopeikin, Mr. Yamshan, Ms. Curtis, Ms. Hodgson, Judge Lucky, Mr. Welsh, Mr. Polefsky, Ms. Lowe, Mr. Tuckman, Ms. Jenna Ellis, and Ms. Coulter.
It's 12.
Okay. All right. Going on to the staff's proposal, number 1. Can I have a show of hands of all who would favor adopting that one?
Judge Pichon, do you mean as proposed revised or the original version?
Would you scroll down to it, Mr. Weiner, please?
Yeah, so it's here. We added the word shall at a member's suggestion was added. Certified practitioners shall be required.
All right.
Was the modification to that.
All right.
I'm seeing Mr. Polefsky, Ms. Cruz, Dr. Getz, Mr. Dinkin, Mr. Tuckman, Mr. Welsh, Mr. Yamshan, Ms. Kopeikin, Ms. Hodgson, Ms. Lowe, Judge Lucky, Ms. Curtis, Ms. Jenna Ellis, and Ms. Coulter. Also
14.
Okay. All right. The next one of the staff proposal, number 2.
Again, this is as with the modifications that were made either at the suggestion of Ms. Kopeikin and Ms. Hodgson or interlineated during the working group meeting, is I believe what you're asking, correct? Judge Pichon?
Oh, yes.
You mean as revised? Yeah. Okay. So on number 2, I see Mr. Tuckman, Mr. Dinkin, Ms. Kopeikin, Dr. Getz, Ms. Curtis, Mr. Polefsky, Ms. Hodgson, Mr. Welsh, Ms. Lowe, Mr. Yamshan, Ms. Coulter, Ms. Cruz, Judge Lucky, and Ms. Jenna Ellis.
14.
Thank you. And
now, if I can make a suggestion,
sure.
Judge Pichon, on this one, maybe ask it 2 ways.
Yes, I was going. That's a good suggestion.
Sorry.
And I think that it should be that way. All right. So now we're going to have to make a choice for this next one. It's number 3 of the staff proposal. I'm going to ask 2 ways. Do you want the language complies with section 6173? And I'll ask for a show of hands. And then I'm going to ask, do you want to not have that language, but you would like to have is substantially similar to that set forth in Rule of Court 3.865 at sequence? Otherwise, it will read as the rest of it will read as it is. Is that how you understand it, Mr. Weiner?
Yes, I'm just afraid to complicate it by saying there could be 3 choices. They might prefer it with complies with section 6173, could be the first choice. They could prefer is substantially similar to Rule 3.865, which is the second choice. And they could prefer to have neither, which was the preference expressed by Ms. Kopeikin. Maybe a way to ask it would be first to ask to make it 2 parts. Do they favor having it with a qualification? And then do they favor having it without a qualification? Then if there's a favoring having it with a qualification, we could discuss which qualification is preferred.
Okay, I'll do that. Yeah, no, it makes sense. All right, so I'm going to ask for a show of hands who favor adopting number 3 without the qualification that you see in yellow. Is that accurate? Okay, show of hands.
So neither qualification.
I'm sorry?
Qualification, meaning
neither qualification.
Neither,
none of the
neither,
highlighted text.
without, so with neither. Okay, show of hands.
I see Ms. Hodgson, Ms. Cruz, Ms. Kopeikin, Judge Lucky, Mr. Yamshan, Ms. Lowe, Mr. Tuckman, Mr. Welsh, Ms. Jenna Ellis.
I see 9.
Okay. All right. May I have a show of hands of those who would include complies with section 6173?
Or is substantially similar or just isolating?
I was isolating. And the next
Okay.
question would be, is substantially similar?
Okay. So isolated, this is just complies with language. I see Mr. Polewski, Mr. Dinkin, Mr. Kelly, Ms. Coulter, Ms. Curtis. And that's all.
5.
5. Okay. All right. Now, may I have a show of hands of those who would adopt the language of number 3 of the staff proposal with the language is substantially similar to that set forth in the Rules of Court 3.865 at sequence?
I see Dr. Getz, Mr. Kelly, Mr. Yamshan, Mr. Polewski. And I believe that's all.
4.
Okay.
So the
I'm sorry,
working
can
group,
you vote twice on these things?
Yes.
Okay, so
Yes.
I guess I should be, I think substantially similar is better than complies. So can you add me to that one?
Substantially similar. Yeah, that would make it.
My first position is that we should not say either one.
and I think the majority, I would say clear majority on the show of hands consensus was to have neither.
That was 9. Yeah. Okay, so Dr. Getz, your hand was up.
No, I don't have any comments at this time. Thank you.
All right. So neither is the position of the working group. Okay. All right. So those are stricken. And number 4, let's see. As it is written on the paper with all of the strikeouts, and Mr. Weiner, this is staff proposal. You can tell me if this is not how you want it presented. Um, I will ask for a show of hands of those in favor of number 4 as it is currently written with all of the strikeouts and new language.
I see Mr. Polewski, Ms. Kopeikin, Dr. Getz, Ms. Hudson, Judge Lucky, Ms. Coulter, Ms. Lowe, Mr. Dinkin, Ms. Cruz, Ms. Curtis, Mr. Welsh, Mr. Tuckman, Mr. Yamshan, and Ms. Ellis.
14.
Okay. All right, very good. And then the last one, I believe that we already had a consensus, but I didn't ask you. How many are in favor of dropping number 5? Show of hands.
I see Ms. Cruz, Ms. Kopeikin, Ms. Curtis, Ms. Hodgson, Mr. Welsh, Mr. Tuckman, Mr. Yamshan, Dr. Getz, Ms. Lowe, Judge Lucky, Ms. Coulter, Mr. Dinkin, Mr. Kelly, and Ms. Jenna Ellis.
14.
Thank you. Okay. All right, so number 5 is gone now, and it looks like from the numbers, we haven't dropped any provisions, but we have modified some. Yes, Ms. Curtis.
Oh, so sorry.
That's all right. Mr. Yamshan?
Oh, I'm sorry. I forgot to lower my hand.
Okay. Anybody else?
And Judge Pashon, I think based on the voice votes, if you will, or the show of hands, you could probably see if there's a motion to adopt what's left, a motion and a second, and if so, it should pass.
Okay, thank you. Mr. Kelly?
I hope this works out for everyone, but I was disturbed by what Ms. Kopeikin told us, which was that the state bar can't say whether or not the federal court panel's process is substantially similar to the rules of court. How's an applicant to know? I'd really like to understand that before I know how to vote on this. If I, as an applicant, ask the state bar or ask Ms. Kopakin, are these substantially similar? Because I've got to verify that they are. How would I know? What do we
If I
ask
may,
an applicant to do? Thank you.
if I can clarify on that, sorry to jump the line here, but I think that Ms. Kopakin's statement didn't exactly portray what staff had said as staff intended it. Staff said was in the context of this working group process, it was not for the state bar to give an opinion as to what court processes would or wouldn't comply. If the state bar, if the rules are adopted, if the Board of Trustees adopts this approach that calls for the state bar to make that determination, I certainly think that staff can and will do that. It just wasn't the time and the place.
Okay, thank you. Mr. Yamchan?
Thank you. I think we may have a tendency, and there's times I'm guilty of this myself, certainly, to focus in on the particulars too much, and we don't step back and see it more abstractly. I think what this does is it says, okay, the statute calls for the state bar to be able to do certain things. Federal courts have their standards. If somebody violates their standards, it can be reported to the bar. The bar can deal with any certified neutrals because the certification program only covers people who are certified. This isn't a broad-based disciplinary system. It's very, very narrow. And my best guess would be that if people are able to qualify, there's going to be very, very little discipline. I'll refer to Ms. Kopakin about how often their disciplinary process might be used. But I think what this does is it recognizes that we can certify people who works in a court system whose process is different from state courts, and they still qualify to be certified. And we recognize the validity of their disciplinary system. I think that's all that this does, and it's important to recognize that.
Okay, thank you. Ms. Kopakin?
Yeah, thank you to both Mr. Weiner and I think that was Mr. Yamshan. I just put in the chat, I think there was one portion of paragraph, what I think is now paragraph 3, or maybe it's 4, that got the one that begins, if the state bar received an inquiry, got a little bit garbled. So we might want to, before we vote, just look at that again. Thank you so much.
Okay, let's see. Mr. Weiner, would you scroll up? So which one, is it paragraph? Is this the paragraph? State bar? Okay. And what clarification did you want to make?
I think we just said after, so I put in the chat that it was follows a complaint patient. I'm sorry, I'm having a little trouble tracking. Oh no, I got it wrong again. Sorry, I got the wrong, I didn't accept. I think I put the wrong language in there. I think it was by the court. It should just be a period after pending investigation and resolution of the complaint by the court, period. I believe that's what it was. Now I'm a little bit uncertain. Just want to make sure we're all on the same page.
And I believe that should be a comma because there was the unless language. However, was changed to unless the state bar determines that deferring will. So it was a comma after court, took out the substantially similar to 3.865 clause.
Okay. Is that acceptable, Ms. Kopakin?
I think that's right. Yes. Thank you so much, Judge Bishop.
Okay. Does it change anything? I think the language is the same.
That's what we were talking about orally. The language.
Oh, okay.
The red line
Okay.
was a little bit confusing. Thank you.
All right, then our consensus should be the same. All right. So Mr. Kelly asked a question. Mr. Kelly, is your question still out there?
I don't really know. I mean, if I'm an applicant, I don't know how to say, yes, my complaint procedure is substantially similar, which is what I think the statute requires. But then I'm not on Ms. Kopeikin's panel. If I were, maybe I would be able to answer that question. And I'm not trying to hang this group up. The consensus is obvious. Thank you.
No, no, no. It's understood, and that's why I was saying that nobody is trying to single out any particular court. It's just for the practitioner will have to comply, and the practitioner will have to know what the court's processes are.
And I'll just say that I think the same issue is going to come up. Does my mediation training comply? Yes, no. Does my experience comply, et cetera, et cetera. So I don't think it's just this that an applicant's going to have to try and figure out and certify, yes, under penalty of perjury, I declare the following. Thank you.
Oh, okay.
If
Thank you for raising it, but, oh, I'm sorry, Mr. Weiner.
I was just going to say, I think Mr. Kelly is right. There are going to be a number of determinations that need to be made by staff. I would suspect that based on the working group's recommendations, if they're adopted by the Board of Trustees, the application will ask a question, not just to certify that it complies, but what is your complaint process? And then at that point, the state bar will need to make some kind of a determination of whether that complies or not, would be how I would expect it to evolve.
Okay, and thank you for that clarification. And the working group has the consensus is that the one, two, three, four paragraphs be adopted. And so if you are all ready, we'll go ahead and take a vote. And so I know it has to be a resolution. So Ms. Mia Ellis or Mr. Weiner, are you?
Yes, ready with that.
I think,
So I have it.
Clarify,
Hopefully
you said the
you're.
4 paragraphs.
I just want, you said 4 paragraph.
Yeah,
Oh.
but that didn't include, we also talked
Oh,
about.
I'm sorry.
the
I already excluded it. So yes. So the vote is on all 5 paragraphs. And if everybody's ready for the vote, then I'm going to ask Mr. Weiner or Ms. Mia Ellis to read the resolution.
Yes, and it's been pointed out to me. So I guess the vote is going to be and not to adopt or not to recommend paragraph 5. Those who are Miss Mia Ellis, is that what you were trying to let me know?
Yes.
This is a little bit of a complicated resolution, so I'm going to read it out loud, and please let me know if I've not gotten it right. But the proposed resolution is that following notice and publication for informal public comment, the Alternative Dispute Resolution Working Group approves and recommends that the Board of Trustees adopt paragraphs 1 and 2 of the Kopeikin-Hodgson proposal set forth in Appendix M, complaints about state bar certified practitioners arising from service in court ADR programs as amended during the working group meeting, and paragraphs 1 through 4 of the staff proposal, and not to recommend paragraph 5 set forth in Appendix M, complaints about state bar certified practitioners arising from service in court ADR programs. And I'm seeing a problem.
Right. Yeah.
1 through 4 of the staff proposal as amended.
As amended, yes.
And not to recommend paragraph 5.
As set forth. As set forth.
Appendix M.
Yeah.
Let me do this a little bit differently. Recommends that the board adopt paragraphs 1 and 2 of the Kopeikin-Hodgson proposal comma, as amended. I'm just trying to accept so we don't have to repeat it, but maybe it's simpler
Dr.
to just
Getz?
make it.
Yeah, I'm just curious as to what our vote actually means on this resolution. I mean, not all of us voted the same on all of the paragraphs. Are we voting just to suggest that we observed that there was a consensus formed on each of these paragraphs, or what exactly does it mean?
Well, okay, Mr. Weiner, you probably should answer that.
Yeah, so what I think, Dr. Getz, is that now there's going to be a vote. So there was discussion of the provisions and amendment, revision of the provisions, and an indication that a majority of the people, members of the working group, support the provisions as revised. And this vote will test whether, I mean, if there's no longer a majority, then we'll have to go back and figure out where the problem is. But based on the hand shows, I think that you'll find that a majority will agree with this in its entirety.
Thank you.
We'll see. I could be wrong.
That's my understanding. Have you completed the resolution yet?
I don't love it, Judge Bashan.
Well, you can certainly take your time.
Would you like to take a break? Is this a good time for a break?
We
Or
can
would you like
certainly
to
do
do
that.
this before?
No, absolutely. We can take a break. So it's
That would be great.
3:47. So let's do 10 minutes and go to, I don't know what that is. How about 4:10?
That's 20 minutes,
Oh, is
Judge.
that 20? Okay. Then
Go to
4:05.
Okay, that's 15.
Or maybe is Judge Pichon 4 okay for the group? Do you mind checking on that? Because I'd love to get to Appendix B as soon as we can.
All right. You said 4 o'clock. That'll give us 3 minutes, and I wanted to give Mr. Weiner an opportunity to finish. So
I show 12, Judge Pichon, with that time right now. 12-minute break. Would
Okay.
that be acceptable to the group?
Yes. What time did you say?
4 o'clock p.m.
Okay. All right. Then we'll recess until 4 o'clock. All right. Yes, Mr. Weiner, thank you for your
Yes.
hard work during the break.
Thank you for your indulgence. So what I've done is I have taken the track changes document that we were working on, and I have pasted this resolution language above it. And this is with, thanks to Erica's suggestion, resolved that following notice and publication for informal public comment, the Alternative Dispute Resolution Working Group approved and recommends that the Board of Trustees adopt Appendix M, complaints about State Bar certified practitioners arising from service in court ADR programs, with the following modifications made during the meeting. So this is the resolution text. I've taken out the headings for this is a staff recommendation and this is a working group member's recommendation, and I've numbered them sequentially.
All right. Thank you.
Showing all of the revisions and showing the last paragraph, which would have been 5 of the staff recommendation, as a deletion.
Okay. Thank you very much. May I have a motion to approve?
I'll move.
And who is that? Ms.
Jill.
Ms. Kopaken?
Yes.
Is there a second?
I'll second. This is Ms. Hodson.
Thank you, Ms. Hodson. Angela, would you please call the roll?
Armstrong, absent. Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubois is absent. Ellis,
Yes.
Dr. Getz,
Same.
Taguchi is absent. Hodgson,
Yes.
Jones is absent. Kelly,
Yes.
Opaken,
Yes.
Cruz,
Yes.
Lowe,
Yes.
Judge Lucky,
Yes.
Palevsky,
Yes.
Robertson is absent. Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Judge Pichon.
Yes,
Motion carried.
thank you. All right, that takes us to the next set of comments, and that will be Appendix B. Appendix B contains the working group's proposed qualification requirements for mediators. 43 individuals or organizations took a position and or submitted narrative comments. There were 139 narrative comments about the tentative recommendations, plus what we've heard from the public comments. I want to make sure those are included. Of the comments that we had received prior to the first meeting, 40% had no position, 15% disagreed, 19% agreed if modified, 26% agreed. The comments included the definition of qualifying mediation, including the 2-hour requirements for mediations and the 40-hour mediation training requirement. So now we'll go to the actual appendix and work through it. All right. So the first set of comments takes us to the second page, page 2 of 2, and that is the 40 hours of qualifying mediation training. I'm sure you don't want me to read that to you. And I know that you've all prepared for the meeting and have gone through it very carefully. So I'd like to hear any comments regarding this 40 hours of qualifying mediation training. Let me see if I can see hands.
I'm not seeing any, Judge Pichon,
Oh, okay.
as of yet.
If does anyone wish to make any changes based on the comments that we have received? Okay. And I'm not seeing any hands. Then we'll do like yesterday. Go ahead. Is there a hand?
No, I was just saying there were none.
Okay. So we'll do like we did yesterday and ask if there's a consensus that the group will adopt that section. So that's 40 hours of qualifying mediation training, and it has A, B, C, D, E, F, and G underneath. Okay. May I have a show of hands of all who would consider adopting this particular section?
I see Ms. Cruz, Ms. Coulter, Dr. Getz, Ms. Kopakin, Mr. Kelly, Mr. Welsh, Mr. Dinkin, Mr. Yamshan, Ms. Curtis, Mr. Tuckman, Mr. Palevsky, Judge Lucky, Ms. Lowe, Ms. Hodgson.
I see 15.
And yeah.
Okay. All right.
And I'm just wondering, in the interest of efficiency, Judge Pichon, when there appears to be like a very strong and obvious number of people supporting something, do you want me to read off all of the names, or do you want me to just let you know that it appears that there's more than a majority supporting or a strong majority?
I think it's
I'm happy
important
to
to
do
read
it
the
either way.
names just in
Okay.
case we miss somebody.
Sure.
Okay.
Yes.
All right. So the comments now take me down to the bottom of page 2 of 2, qualifying mediation for the purposes of certification and certification only. And 1 and 2.
I see several hands. I don't know if they're relics of the last. I see Mr. Yamshan
Okay, Mr. Yamshan.
and Ms. Curtis
Start with Mr. Yamshan.
and Mr. Welsh. Mr. Yamshan has lowered his
I'm
hand.
sorry, I forgot to lower it.
Oh, okay. Who is the next person?
Currently, Mr. Welch and then
Welch?
Ms. Cruz.
All right, Mr. Welch and then Ms. Cruz.
Thank you, Judge
And Ms.
Piscon.
Curtis.
I appreciate this space. The comments that I'm kind of making now are just from that experience. That one, or just kind of have to give the background. One, I was in the mediation working group, right? So there was communication about this at that time. The comments that we have seen throughout that have come from this space, there are many that have been a part of my organization that provides day of hearing mediation services. The organization does provide, this year is roughly 1,600 mediations, 1,200 resolutions. The average case is around 1.25 hours, right? That we provide those mediation services. I think there's a lot of mediators that are trying to be acknowledged and have some type of recognition for the value and the work that they provide, while also seeing the understanding of this state bar certification and what it means in the context of stuff that, or mediations that need to happen beyond just the day of court, right? That they need to show that experience of, that's more involved in mediations that might be more comprehensive than just what you can find in court, even though that those small, quicker mediations have a lot of content and skill and emotion and all parts of things that come into play there. But it is one of trying to, recognize that value while trying to find a way to move that forward. There is a certain proposal for that, but I can hold that and for, a conversation or Mr. Weiner about that, that I had communicated and just tried to see if there's a way that we can address this issue of 2 hours effectively and see if there's any further conversation in this space.
All right. Thank you. Ms. Curtis.
Yes. Well, I just was debating about whether to hear that before I said a few things, but I think they're pertinent anyway. And first of all, I want to say that I read all of the comments really carefully. There's a number of the people who commented that I recognize and have very high regard for. And so and I also want to harken back to the very beginning when Mr. Stein made his remarks, because I do agree that including mediators with this deep experience in short mediations, where all of the skills that I particularly value as a trainer and also as a practitioner, really have to be honed and perfected in order to create that kind of understanding between people in a very short amount of time. And I want to say that the working group benefited so much from Mr. Welch, from your contributions to help us all understand this sector in much more depth. And Maddie Robertson, who's not here, also contributed to that. So we had robust and continuing conversations, and many of which were around this issue. So we had hoped that we found a consensus. Well, we did reach consensus, and then I hear, that these comments have raised it to, have brought it forward to us now. So we really do need to have a additional discussion about it. But I want to say that in the very first working group that we had, working group meeting for the mediators qualifications that we had, we started, and as the leader, I put this on the agenda front and center with talking about what the interests were and what we were really charged with doing by the working group charge. And first on the list, what we were to develop rigorous professional standards balanced with an inclusive program that accommodates the wide variety of ADR firms, providers, and practitioners. So right from the beginning, we were focused on this and really not wanting to exclude people with less experience or, and at the other end of the spectrum, people with lots of experience who hadn't had some of the other requirements. And in particular, DERPA program volunteers, recognizing the value to communities and the abilities that really were required. And but also to promote public confidence and promote consumer protection. So what I I mean, we compromised to reach the 2 hours, honestly. And the thing that I'm concerned about, and I'm hoping, Mr. Welch, that you have an answer for this, is that we do find a way to assure the public that the mediators who are certified can manage all of these things that perhaps aren't really present in a 1.5 hour mediation or a 1 hour mediation. And Alan set some of those forth in the document that he sent us in preparation for this conversation. But they're, convening, which is often quite complicated. Dealing, some of them I think are less important, but I would say one of them that really matters that I didn't see mentioned is, is helping parties really absorb clearly what their alternative to a resolution might be. And that might be with using lawyers to help bring in the law, learning to use how to work with lawyers, also how to really help them think about their interest, not just in the context of a brief conversation, but in the context of examining multiple perhaps offers or creative solutions or, things that might go on for a day or even a longer mediation. So that's my concern that, and I don't think it's helpful for us to kind of say somebody's certified for a mediator, a mediator certified as a community mediator or a DERPA mediator, because then it opens, should we have family law or should we have other specialized fields? So we kind of dismiss that in our group. And because I do think that communicates perhaps a lesser, in the minds of people who read it, a lesser level of qualification. And I really don't want to see that. So what we discussed in our meeting was that there are ways that people who want certification beyond, um, for reasons that personal reasons, or maybe they want to develop as a professional, that they have a way of doing so by volunteering on other panels. It even occurred to me that DERPA might, there might be volunteers within the DERPA community who are practitioners or even trainers that could fill in some of these pieces for people who want to have more extensive training. So anyway, I'll stop. But I think we thinking creatively and perhaps the bar could even support some of this. And I think it would be a worthy effort because I do think we need these people. And I do think that the field benefits from folks who really are able to focus on the conversations and see beyond an evaluative approach. So thank you.
Thank you, Ms. Curtis. Ms. Cruz?
In our very first working committee meeting, the group was asked on an individualized basis what their biggest fears were or goals that they wanted to avoid in terms of allaying those fears. And a lot of people mentioned inclusiveness as a goal and not excluding people or creating artificial barriers as something that they really wanted to avoid. And after reading just the momentous number of comments that came in, I personally think that we are going to do both court mediators and the court system as a whole a great disservice if we adopt this 2 hour requirement. From the beginning, too, I was very concerned about arbitrary numbers. I have seen 15-minute mediations that check all the boxes. I have been in a 12-hour mediation as a litigator where the mediator didn't do anything or exhibit any of the skills that you would want to see. And so I personally plan at some point in this discussion to make a motion that we move towards what the vast majority of our commentators on this topic suggested, which is just to do a total number, as opposed to 2 total hours for one qualifying mediation. Because ultimately, I don't think it really helps consumer protection because I don't think the two things we're trying to correlate are necessarily completely correlated. And I know that we are going to exclude a big class of mostly volunteers and people who are helping to serve our community from being certified. And that seems contrary to what many of us said at the start of this project was one of our main goals. So that's, I personally, after this discussion, would like to move to either modify this or think about it more because I don't want to exclude those people.
Thank you, Ms. Cruz. Mr. Kelly?
I will note that one of the intents is consumer protection, and I'm actually very concerned, having heard the input from the specialists in divorce where there's minor children involved, with anybody being certified for a general, I'm a certified mediator handling cases of divorce with minor children where the state's interest really is the welfare of the children. And the family mediators said this was way too low a requirement to adequately handle the complex issues of divorcing parents with children. So I'd like to just bring in their comments and ask us to remember that when the state bar says, "Hey, you're a certified mediator, you can mediate any kind of case," at least in a consumer's mind, it would include divorce for parents with minor children. Thank you.
Thank you, Mr. Kelly. Dr. Getz?
Yeah, I just wanted to add some helpful information, I think, to the group. MC3 didn't really define a qualifying mediation. We did go, as Mr. Stein alluded to when he came in for comments on Monday, to a total hour requirement. Now, ours was set pretty high at 50 total hours, but that's how we sidestepped this whole thing. So if the group wanted to go to some total hour requirement, I thought that might be helpful to know. I will mention, however, also that all of the mediators who work for DERPA groups have the opportunity to volunteer for other venues that will accept them, I believe. I think the first one would be the state bar. That have state, they have attorney-client fee disputes, and they're always looking for volunteers, and those mediations last generally much longer than 2 hours. So I did want to say that we're not necessarily excluding somebody. We're only potentially excluding people who have devoted just totally to small claims mediations or smaller matters. So I wanted to present both sides of the facts. Thank you.
Thank you, Dr. Getz. Ms. Copagan?
Oh, you're
Ms.
muted.
Copaken lowered her hand as well. I'm not sure whether
Oh, okay.
that was deliberate or not.
That was because
I
I
see.
meant to unmute myself. I did the wrong
Oh.
thing. Sorry.
Oh, okay.
Low blood sugar. Thank you all. I wanted to second with what Ms. Curtis said about just the landslide of and really impressive people. And I also read their comments and thought it was really important that we consider those. I would really be interested in hearing, I don't mean to throw her out there, but I would be interested in hearing from Claudia Coulter, who is in the family mediations range. And I recall from our subgroup, I was on this subgroup, one of the discussions we had is that a lot of in the family context, particularly where there are minor children, things, a lot of times the sessions are not necessarily, start to finish. They may be multiple sessions and maybe, what many of us would consider more facilitation, but, it's sort of a longer form and over many sessions that might cumulatively be 2 hours, but maybe not. And that's why we have the in one or, multiple sessions. So I think that one of the other aspects I think is important. We were unclear, I think, when we got together how much folks in like the DERPA programs would be motivated to get certified. I think we have a resounding answer to that now. One of my concerns when we were talking about this was that those day of court programs, that it not look like a lower tier of service for the consumers if it's in fact not, because that's an important from a, a justice perspective too. If they're getting good service, we don't want it to look like they're not just because somebody isn't doing long form mediation. So I'm certainly interested in hearing and what others have to say about this, but I would be inclined to try and find a way to make sure that those folks are being respected and brought into the fold too.
Thank you, Ms. Kopagan. Ms. Doherty?
Thank you. I just wanted to really quickly just to clarify something that Dr. Getz said. So we currently as an organization do not have a fee mediation program. We have a fee arbitration program. However, we are in the process of developing a fee mediation program as an organization. And there are many other organizations that do have a fee mediation program that might qualify. I just wanted to make that really clear. I think that is a great path for, depending on the result of the working group conversation, for people to participate in. And I think that our arbitrations allow for non-attorneys to participate, and I'm assuming that our mediation program would do something very similar to that as well.
Thank you, Ms. Doherty. Mr. Yamshan?
Thank you. I have a question. Are there any DERPA programs that only do exclusively court-annexed mediation? Because most of the court-annexed mediation programs of which I am aware are run by a community mediation center. And a community mediation center certainly gives people the opportunity to do other kinds of mediations, which many times can last much longer. And the question was inspired by Dr. Getz's comments that there may be other avenues to get the experience. I'm not going to enter the debate about what should be a qualification, but I'm just curious about that, because if the court mediators have the opportunity to also handle community disputes, there may be those opportunities to get the longer mediations in. Thank you.
Thank you, Mr. Yamchan. Ms. Coulter?
Thank you, Judge Pichon. Okay, just a couple of comments. It is very hard for non-attorney mediators to join volunteer panels. So for example, when LA County courts say they need more mediators, the notification will go out that you must be an attorney. And it's like, don't worry, we'll train you. We have so many trained mediators who do not qualify. So they can't necessarily just volunteer from place to place to place. It's not impossible, but that is a challenge for them. I'd also like to say if Dr. Getz makes a proposal to just add more hours, like MC3, I would be in full support of that. I think that would help with that. And then also as a family mediator, it is like what Jill said. And one of the things that came up in our discussion was in the mediation subgroup, it is very challenging in family mediation to meet for 2 hours at a time. We don't have these marathon sessions. I know some do. That's usually if those clients have attorneys and they've scheduled for all day. The vast majority of these clients do not have attorneys. And so they come in a limited capacity, in a limited emotional capacity. We meet for an hour or so, they'll come back again. So this is why that was worded in one or more sessions. And then lastly, family mediation is very facilitative. It is, because at the end of the day, these are their children that the parents are deciding these issues for. So mediators should never, ever, right? We should never, ever be making decisions. And yes, the best interest and welfare of the children is important, but at the end of the day, the parents ultimately make those decisions. That's all. Thank you.
Thank you, Ms. Coulter. Mr. Welch?
Thank you very much. I just wanted to, so as a DERPA provider in Los Angeles County, we're responsible for 15 courts and providing small claims, civil harassment, and UD mediations every day at those 15 courts. And we have a budget of about 2 judges to do that work. So we need to have volunteers. We need to have others to help support the services that we've committed to. our organization primarily focuses on day of hearing services, right? Like day of hearing, those smaller services. So as an organization, if you were looking at a DERPA, that would be my organization, right? Are there other opportunities? Yes. I think that to put it in a place where this is a very specific kind of piece, there's a bit of, I mean, I'm not going to make the apology, but I will say yes. I mean, it is one where it's one of value and importance for the community of these services that we provide, but it also is to that extent for those volunteers and those mediators and that reliance on non-paid individuals to do court work. There are non-paid mediators doing a lot of work for the courts right now, right? Mm-hmm. And so the fact that nobody's getting paid to do this work is, I feel, that has to be supported a lot more. That's a full other topic. But at the end of the day, if we are going to put restrictions on this, then we are putting it in a position where volunteers, where we are just struggling to even find anybody, I'm not saying struggling, we have a capacity to fill certain things, that if we start restricting that even more, those volunteers will be like, well, you're doing nothing for us besides public good, and us wanting to do that, it's not leading to much, towards that advancement. That argument, we can set that aside. I think ultimately what I was trying to propose is this idea of potentially having a traditional, the 3, 2-hour traditional mediations, that you cannot do that in a day of hearing courthouse setting. Like, that is restricted, and that you could maybe have 12 to 15 cumulative public service hours that would count towards public service mediation that last at least 1 continuous hour, right? And that could be verified by an organization of your work that you do, but some kind of blended hybrid about public service mediation, because any concern in this context, as it is public, as we all know, that we go back to information that's within any legislative dynamic, is that you look back and say, okay, well, the state bar said that a qualifying mediation is only 2 hours, right? That then sets the bar for the future of our communications. If I have to go back to DERPA and look into that statute or go into other things, how does that attach to it? So to have some acknowledgement could be beneficial about that public service mediation, and having that valued, phrase or something of that nature could be important for future dialogue about our programs and how we work through that.
Thank you, Mr. Welch. Ms. Hodgson.
I don't want to speak as though I am a DERPA provider because I'm not, but I have worked with DERPA providers in my county with my court. And I just wanted to reiterate or emphasize that every courthouse, every county, what looks like ADR and DERPA provided ADR can be very different. So I am reluctant to apply the sort of a one size fits all, or DERPA is just small claims idea to this discussion. In my county, we have DERPA provider that does family law mediation, that does probate mediation, that does unlimited civil mediation. They do civil harassment restraining orders. They do small claims, all sorts of things that I think wouldn't, as this group has been talking about DERPA, wouldn't necessarily traditionally fall under that idea. So I think if we look at the hybrid model that Mr. Welch suggested, that might be an interesting way to respect and appreciate the hard work that DERPA affiliated mediators do, while not making anyone else feel like, well, hey, I'm convening and I'm mediating for hours and hours at a time. I think there's a balance that can be struck.
Thank you, Ms. Hodgson. Mr. Weiner?
Thank you. So the importance of this discussion can't be understated, right? There are, as has been mentioned, people who are altruistically volunteering a great deal of time. It's important to them to have a place in the mediation program. There are also, I think, legitimate questions and concerns about public expectations and consumer protection. If there's one mediator certification, to Mr. Kelly's and others' points, if someone has a certain type of experience in the courthouse, and then they're selected because they're certified and presumed to have experience in handling the kinds of, ongoing matters that Ms. Coulter was talking about, there's going to be, I fear, a disappointment in public expectations. And I think it raises concerns, at least for me, about, what's the ultimate meaning of the certification program. And I'm not saying that the meaning requires that there be, exclusion of day of court mediation programs, but I'm saying at the end of the day, I think we all want certification to be a meaningful indication to consumers that this is somebody who has been vetted, that you can count on to do the job, if you will. So again, not to underplay the importance. I have a lurking question that may help us figure a path forward, which is, are we talking about, is the issue that we're really discussing and trying to solve for, is it reducing the number of out-of-court mediations that need to be done? As Mr. Welch was saying, having other community mediations that are longer and done outside of the courthouse and coming up with some kind of a hybrid model? Or is it certifying mediators, potentially certifying mediators who've maybe done 50 hours entirely in the courthouse, and they have no interest in mediating community cases or fee mediation cases or lemon law cases or anything else? They like to go in and provide their service in the courthouse. If we're talking about just that group of mediators who may only want to do provide service in the courthouse, I have a real concern about the judiciary's perspective on the state bar coming in and saying, this is a certified mediator who the state bar has certified to do, courthouse mediations, or generally, which gets me to a little bit different point, which is more of a process point. I think, this working group has had lengthy and multiple meetings to talk about some of these issues. The mediator subgroup met probably 10 times. And as several of the members have said, this was top of mind, and then made recommendations to the working group that were discussed. I feel like there are more voices that it would be beneficial to hear from on this. One of them I'm going to call out, and that's Mr. Dinkin, because he also administers a community mediation program. But it seems to me that this conversation, rather than the working group responding to a large number of passionate comments by people who have important interests, rather than doing that, as a result of a 1 hour or a 2 hour discussion, I think there are more people and more time that should be spent on this. I'd like to hear from some of the judges or judicial officers who oversee these day of court calendars, and hear what their views about certification are and what their experience is and how much experience they think the mediators who appear before them should have. I think hearing from more dispute resolution DERPA provider organizations, I think hearing from organizations that oversee the DERPA organizations in a county like Los Angeles, I think Mr. Welsh has mentioned, has 13 different, I may have the number wrong, but there are 13 DERPA provider organizations. And in Los Angeles County Department of Consumer Affairs has a DERPA program office where they oversee those and they contract with those mediators. Other counties also have programs like that. The State Department of Consumer Affairs has an office that is at least theoretically responsible for statewide oversight of the DERPA program. And I feel like the working group would be doing disservice to this important issue by making a decision, based on an hour or 2 hours of reflection on the passionate and valuable comments that were received without really thinking this through. I guess one other issue that comes up has already come up, and that is, so how does that fit in with the complaint process that the courts have I mean, that the working group has just adopted. And, are these complaints then heard by the DRPA program organizations? Are they heard by the court? Are they heard by some other provider organization? So I just feel like it's an important issue and it's a complicated issue, and it's an issue that should be given more thought.
Okay, thank you, Mr. Weiner. And Ms. Cruz, before you comment, Mr. Weiner has touched on something that you mentioned. It was one of your last comments, and that is we should discuss this further. So I wanted to make sure that that point is raised before you perhaps make a motion, because you said that that's your intent. And that is, I could ask staff on their position of what it means to take more time to discuss this important issue. And if it's something that the working group can revisit either as well, it will be as a whole group, but whether or not there can be a subcommittee set up to give this the attention that it needs. And having said that, staff can say, "Oh no," but first, Ms. Cruz, what is it that you'd like to say?
Well, I'll wait and let the group answer that question of whether we want to defer this and create another subgroup on just this point. And then I'll make my comments after the group speaks on that.
Okay, let me ask staff if they wish to kill me first.
Well, I will comment. I think what I've heard from Mr. Weiner is the suggestion that there are other experts possibly outside the current working group makeup that can contribute to the conversation. And so I would be inclined to have the working group address and resolve the current working group address and resolve the recommendations that are currently that you've already resolved, the tentative recommendations, and get those to the Board of Trustees. And we anticipate that there will be other areas of the program that the bar needs to address. And it's just not this particular issue with defining qualifying mediations for a day of court. There are others. And so I don't want to say I'm opposed to it, but my thought is the timing of it and whether this is the full group that can contribute to the conversation.
So I think we're fortunate to have Ms. Doherty here, who would be an important voice on whether the state bar can explore this issue further, or what it would, what the policies would be around bringing in other experts. And I guess my thought in response to what Ms. Ellis just said was, if the working group could proceed with recommendations for, what went out for comment with the qualifying mediation definition, or some maybe minor adjustment to that that's not intended to grapple with this whole set of issues, it would seem to me that it would be beneficial to move forward with the program to the extent possible while exploring that.
So
All right.
I'll just sorry, Judge Pichon.
Oh, Ms. Doherty, go ahead.
Yeah, so I think there's two separate things here. So one is, I think this working group has already acknowledged that there are many things that are not being addressed in this first iteration. I mean, that's in the working group's charge in and of itself, right? Is to look at things with the thought of revisiting. We are currently limiting what's being proposed to mediators and arbitrators, and as has been discussed, there are many other, alternative dispute resolution types that are not being resolved or addressed. And some have mentioned that this is perhaps only addressing things that weren't even the impetus for this statute altogether, right? So there are things we will be going back to. That being said, I do think this is a little bit of a threshold question here as to whether you want to, in the first iterance of this program, make a determination to include or exclude in this court-connected area. And that's not saying that if they are excluded right now, they would never be included in I don't want to make such a broad statement, but I think that's kind of what we're getting at to some extent by having that 2-hour minimum. But I do think that that is something that perhaps this working group does need to decide. And then if the consensus of the group is yes, 2 hours is the threshold, or to Dr. Getz's point, maybe 2 hours doesn't make sense and we need to just do more qualifying mediations altogether as a number. I think that was Ms. Cruz may have said that as well at one point. But I think I don't want to say that this is not something that the state bar would move forward if that's the ultimate determination. I think that's something we would like to move forward, and we could certainly propose to the Board of Trustees and do so. But I think before making that determination, you all need to decide what you want to do with the court connected today, in the first iterance of this program.
Thank you, Ms. Doherty. Let's see, Ms. Cruz, go ahead.
I just want to second Erica's point, right? I think today we should decide at least two things. Do we want to exclude court mediations and mediators from this program entirely? My guess in hearing from a lot of you is no. And do we want to create a second sort of like class or a second sort of set of guideposts for them? And again, my feeling in listening to a lot of you is that that is not a good thing for our system. And then we are at a place where if those two things are true, those two things which I think we should decide today, I think we're at a space where this whole area is kind of held up on this point. Because without these numbers on that, I'm not sure what we're recommending on a lot of it. So I definitely think it makes sense for us to maybe do a consensus on, do we want to have a special tier for court, facilitated mediations, and do we want to exclude them entirely? I don't think either one of those things would serve the court.
Thank you, Ms. Cruz. Mr. Yamshan.
Thank you. With all due respect to Ms. Doherty and to the DERPA administrators on the working group, I think that Mr. Wiener's suggestion has some real value to it. Bring in some judges whose courtrooms are affected by these day of court mediations and other court-connected mediations. I don't know if you would call it hearing from the consumer, but it would certainly give us a different kind of experience than that which people have, which is certainly valuable and very, very extensive. I'm not belittling anyone. But early on in the program, we had an outside expert on certification programs come in and speak to us. And I see no reason not to have other outside experts who do have some expertise beyond those of the extensive expertise of this working group. So I know the clock is ticking and the Board of Trustees has a lot of expectations waiting for our work product, but I think this issue is so important that if we can get more information and come up with something that can satisfy the interests of all the parties, at least to some extent, that would be a very productive thing to do.
Thank you, Mr. Yamshan. Ms. Kopeikin?
Oh, you're muted.
Ms. Kopeikin?
Sorry. Yeah, so I just want to tease out a little bit. When we use the term court connected mediation, we have to be careful. So you're talking about these short form day of court mediations in the DERPA context, and so that's one thing. So I don't want, it's not one size fits all. So for example, in mandatory settlement conferences or things like, or my program, people do long form mediation. So it's not just court connected, it's these specific kind of day of court. And I don't want to pretend to be an expert in that. I've volunteered pretty extensively in those programs, but I have never been involved in administration of them. So I would certainly defer to Mr. Dinkin and Mr. Welch and others. I just have a question though, and I think when we met in our subgroup, some of the things that Mr. Wiener raised, we talked a lot about, and I thought they were important points on, if people want to have this sense of, a certain amount of experience. But as I was listening today, I questioned, the certification doesn't mean that somebody is certified to be an expert in family law or intellectual property or any other thing. I mean, just like when you get admitted to the state bar, there's some basic level of criterion, and you're expected to have certain knowledge, but you aren't saying you're an expert in those areas. And I think that would be true here too. That begs the question of that doesn't answer the question of what should the baseline criteria be, but I thought it was important to not generalize too much. So I'll just raise that.
All right, thank you, Ms. Kopakin. Mr. Dinkin?
In our organization, we really run the gamut of mediation. So we're a DERPA provider. We do small claims court mediation. We also do community mediation. And then we have a very substantial fee-for-service mediation that cuts across many different disciplines: personal injury, construction defect, probate, medical malpractice, for example. And so I do think even within the fee-for-service arena, just as was said before, if someone is an expert in construction defect and is certified, I certainly wouldn't use that mediator for probate. And someone who is an expert in probate and is an attorney who has been practicing probate law for many years, I don't use that individual, for personal injury cases. So even though they could be certified as a mediator, that wouldn't mean that they could then handle cases outside their realm. And then within the community mediation side, we have folks that are doing small claims court mediation. Those mediations are much shorter, but I would say that they're as qualified in terms of their skill set as someone who might do a community mediation that could last 3 hours. So I think in terms of the DERPA area, it's really interchangeable, but I certainly often wouldn't use almost never a community mediator in a fee-for-service case dealing with attorneys. So I see it's interchangeable between small claims court and community mediation. And then on the fee-for-service side, it's not really interchangeable between the mediators, and I wouldn't cross between community mediation and fee-for-service. So I think it's how you define what certification actually is.
Thank you, Mr. Dinkin. Mr. Weiner?
Just a question for Mr. Dinkin. So do some of your mediators, and your program has been around since the 1980s, I think, and you're
Right.
leaders in certification initiatives back in the 1990s.
Right.
But is there crossover between your day of court mediators and community mediators? In other words, can somebody who maybe starts out being a day of court mediator, they express an interest in doing community mediations or ultimately becoming on the fee for service panel? Is there that sort of room for, I don't know if you want to call it even growth? It might be arguable that a fee for service personal injury mediation mediator would grow into a day of court program. So it's not that there's, necessarily one direction, but is there some opportunity within the organization for people to get experience with different kinds of cases if they show promise?
It's possible. I mean, there's certainly day of court mediators or small claims court mediators that can easily move over into community mediation doing basic community mediation non-court cases. There's some individuals who initially get practice as like an attorney through community mediation that would eventually perhaps go onto a fee-for-service panel. So that is possible. It doesn't happen very often within our organization, but I know that many people, start in the field as a community mediator, gain a lot of experience, and then move into fee-for-service. I think that is not an uncommon path. And
if I can, just another question occurred to me. So Your organization also has its own certification program, doesn't it? When you certify mediators or
Well, we do have a mediation certificate in the sense that we do a training where 40-hour trained people go through that. And at one point, we did have a mediation certification where we'd actually have individuals that want to become certified as a mediator, and they would go through simulations, and it was like a 6-month program. But we haven't continued that in the past maybe 8 years. We ended up not doing it. It's too time intensive for us to continue that program. But we did it for probably 15 years.
yeah.
Okay.
Thank you.
So we've had a very deep discussion regarding qualifying mediation. Um, so I'm going to have to ask the difficult question. Are you ready to indicate whether or not you would support this particular section? And let me see if there's a consensus on whether you would support it. Or, and the second question would be whether you would not wish to do that. So, may I have a show of hands of who would like or who feels that they would support uh, Mr. Mr. Weiner? I think it's the whole section.
Yeah, I think the only discussion was really around the first point, but
But it we
are you talking about the definition of
no,
qualifying
no,
mediation?
I'm thank you. Now you have the whole thing highlighted. So the consensus vote on whether or not you would agree to adopt this particular section 1 and 2. May I have a show of hands?
Mr. Kelly,
Okay,
Just one.
one. All right, and may I have a show of hands of who would not adopt this particular section?
Ms. Cruz, Ms. Coulter, Mr. Dinkin, Judge Lucky, Mr. Welsh, Mr. Yamshan, Dr. Getz, Ms. Hodgson, Mr. Tuckman, Ms. Lowe, Ms. Kopakin,
I see 11.
and I can't tell about Ms. Ellis. No,
It's
that's
11.
11.
Looks like,
And that's a majority.
yes.
Okay, thank you. All right, so the group has spoken. And now the comments will take us to the very last paragraph, which is qualifying mediation related activity.
Just be shown, I do see two hands up, just if,
Oh,
oh, sorry, I didn't know if you're aware. Miss Cruz.
Miss
Miss Cruz's hand.
Tucson, yeah, if I may, do you think that it would be helpful for us to determine those three things that were suggested by some of the group members and myself? So if the group wants to do a subgroup to consider this more, if the group thinks it's a good idea to exclude court-connected mediation programs from this and develop a different set of rules for them, etc. And then if we want to just exclude them entirely, I think the answer to those three questions is an important piece in terms of where we're going to go with this.
okay. Before Mr. Weiner speaks, Ms. Cruz, I believe it was my understanding that by saying no to the qualifying mediations, that the group was very concerned about not excluding the others. And that's why the vote went as it did. And now there is no longer the requirement. Well, it depends on how you vote. The consensus is that the group does not want to say that there must be at least 2 hours of mediation facilitation. And that was to keep the group from excluding anyone.
Okay, so our conclusion as a group is that 6 mediations, no matter how long they last, without any definition of qualifying mediation, is where we're going today.
No, I can't answer that, and I didn't say that. So if that's if that's what you want to ask the group is, do they want to revisit it? I can ask them. But the response I got from staff is that they would try to do this, reconsider, but they could not say that that was guaranteed that we would be able to. But that if you want, we can send the message to the Board of Trustees that that is something that this group would like to see.
Judge Bashan, if I
Yes,
may.
Mr. Weaver.
Yeah. So first of all, I'd just like to raise concern, albeit objection, to the way the question is framed as does the group want to exclude, and I won't say court connected, but does the group want to exclude mediators who serve in court connected or a day of court programs? I don't think that's how it's been framed at all. Those mediators, even under the proposal, which the group decided to reject for now, would not be excluded from the program. They would have additional requirements. So I just think it's important, in fairly framing the issue to keep that in mind. There's nobody saying that somebody who mediates in day of court programs couldn't be certified under this 2-hour provision. Thank you.
Okay, Ms.
And
Cruz.
also, I guess if I may, just on the process point, Judge Bashan, I would suggest. I did not take the show of hands indicating lack of support or opposition to this highlighted paragraph. I didn't understand it to mean that people were voting to delete it. I thought, as Ms. Cruz had kind of suggested, that the option it offered was, should there be further discussion of some alternative provision or of an alternative process for figuring out something more suitable.
All right.
That was just my understanding.
Well, I thought the question that I asked was whether or not the group wanted to support this particular paragraph.
Yes.
So the answer was that they did not. Is that incorrect?
No, I think that's correct.
Right.
But what I don't think it answers is, and then what? So we don't want to support this. What do we want to do next?
Okay.
I agree.
Ms. Cruz, I think that you were responding to that. What do we want to do next?
Yeah, exactly. And I think one thing that is important for us to decide as a group today, two things. I don't think anyone wants to exclude them. And so, but there's this suggestion sort of that's been made that we should explore. Do we want to make a separate sort of set of rules for just court mediation programs? And I think that it would be helpful to get the groups like up or down on that. Should we have a one size fits all, or should we do two things? And I also think it's important to get the group's feedback on whether we think that there should be a subgroup on this issue, the and what now issue or not, or whether the group is capable of making a decision a la what Mr. Stein recommended of just converting instead of 2 total hours times 6 of just 12 total hours or 50 hours as, for example, Dr. Getz's group has, etc.
And Mr. Yamshan has his hand.
Mr. Yamshan?
Thank you. Before I read all the comments on this issue, I was prepared to vote for this. And after reading them, and particularly after hearing the arguments and some of the testimony, it's very concerning. The working group decided quite some time ago that we didn't want to have subcategories of certification. So I think we're not doing ourselves any favor by carving out a day of court mediation classification. Personally, I would like more information. And as productive as this new subgroup could possibly be, I'm not sure that they would be able to come up with something that would put us in the same place of argument that we are in today. Unless the subgroup is able to do some kind of research and seek out information that we don't already have. So I'm going back to Mr. Wiener's suggestion that we need more information. And I'm sure there's a way to overcome the objections that will be fair and equitable to anyone who wants to be certified. But we just don't have that data yet. Thank you.
Okay. So I will do that, Ms. Cruz, but I need to make sure that I have the wording correctly. So I I don't think the question would be, do we want to exclude anyone or any group? But we would inform, we would take a vote that we would like to inform the state bar that this group would like to consider and take in more information regarding day of court providers and others similarly situated. If you'd like to say that better, please do.
Well, I guess the first preliminary question that I was thinking is, do, do we have a consensus that we want a one size fits all, as Daniel was saying, and I think we did talk about at length before, or do we want a separate set of qualifications and numbers for just court facilitated slash connected programs? Because if we're doing a one size fits all, then I think that we need to unfortunately consider not just court programs, but all the other types of mediators too. So I would say that that would be the first question to pose to the group. Do you want a separate set of qualifications for court certified mediators or not?
May I make a comment and propose a friendly amendment?
Yeah.
And that is that right now there are three paths for mediators depending and three paths for arbitrators depending on professional background, whether there's a JD. I'm trying to think for if I'm saying this accurately so three paths: mediators trained within 2 years, mediators trained more than 2 years before application, mediators without the 40-hour qualifying training. One possibility, rather than creating a separate class of certification, would be to create a separate path for certification. And I just put that out as another approach that may not be as problematic to some as saying, okay, we're going to carve out this one separate category of certified day of court mediators and everybody else is in the other pot. I'm just saying that could be approached that way.
Okay. How about that, Ms. Cruz, that the question that I would ask the group would be, do you wish to set up a separate path or develop a path for certification of the court facilitators?
Yeah, I like that. And I'm just looking at Chris's comment too. Something like, Noah's suggestion of 12 hours total of mediations plus, and then we would go back up to path, I think it's one. So it'd be path four, and you would have the same training requirements, right, Alan? Maybe like just talking out loud as like, and then you would add a total number of hours instead of it's got to be this length,
Ms.
something
Cruz,
like that.
Ms. Cruz, I don't think that we'll be able to do something like that today. I'm going to go back to what Ms. Curtis said at the very beginning, and that's how much time the subcommittee spent on this. And I don't think that we will do it justice if we try to change numbers at this time. Creating or developing a path would take some deliberation by the group. And I think that we would need the time to do that properly. So I'm asking if there's any objection to asking the question of would the group like to develop a separate path for certification for the court facilitators?
You're asking for a show of hands on that?
I'm asking, first of all, is there any objection to me asking that question or asking for the consensus of the group regarding that?
May I ask for clarification, please? A
Yes.
separate path would not result in a separate certification category. Am I correct?
I, no, it's just what I said, a separate path.
Okay, thank you.
Welcome.
May I ask for a friendly amendment to the way you've described it, Judge Pichon? You said
Sure.
court-connected mediation, but I think we're really talking about the short form day of court mediations, and that's an important distinction.
Well, just give me the title. What would encompass that group?
Court-connected mediation?
Court connected?
No, I'm sorry, not court connect. I'm sorry, day of court mediation.
Okay, day of court
So
mediation.
if I may make another friendly amendment, I think the question that we're grappling with, that the group is grappling with, it would be characterized as for mediators who have not completed 6 qualifying mediations as, as defined below. So it could be day of court. It could come up in some other context as well.
So who have not completed 6 hours of what?
Of who have not completed 6 qualifying mediations,
Okay.
as was defined in this provision. So an alternative to the 6 qualifying mediation definition.
Okay.
To the extent I was proposing an amendment, I accept that.
Okay. All right. So the question to the group would be, your position, or do you agree that we should pursue or develop a separate path for certification for day of court mediators? I'm sorry, that's wrong. Should we develop a separate path for certification of mediators who have not completed 6 qualifying hours of mediation? Is that accurate?
I think that's what I was suggesting, Judge Pichon.
I believe you said 6 mediations that met the hour qualification, so I think it got flipped. No,
So I said 6 qualifying mediations?
Yes, that's correct.
Okay, yes, that's what I said. Okay, that's fine. And Mr. Wiener's writing it down. Please make sure that what I said is accurate.
This was the
Okay. May I please have a show of hands of all who support this? Show of hands, none?
I see Dr. Getz, Ms. Coulter, Mr. Welsh, Mr. Yamshan, Ms. Cruz, Ms. Hodgson, Mr. Palevsky, Mr. Tuckman, Judge Lucky, Mr. Dinkin, Ms. Kopakin, Ms. Lowe. Am I missing anyone? Ms. Ellis?
No, I don't think she has. Did she have? Oh, yes, she did. Sorry.
She had it.
13. I have.
13? Okay.
You also had Curtis. She was quiet, but she had her hand up.
I saw Miss Curtis. All right. If you have other stuff down there, Mr. Wiener, you have training.
Yes,
Well,
I was just suggesting here ideas of things that might be discussed here. So mediators who've not completed 6 qualifying mediations.
If you don't mind, if we could leave it with
I'm
the
taking
vote. I'm just thinking of the time.
Sure.
Thanks. All right. So I think that means that we have not left anybody out and that we will make sure that we develop paths for everyone who would like to be certified. Thank you all. I mean, I hope all who have commented have seen how much this group cares, that no one is excluded. Everyone has an opportunity if that's what they want to do. We have one more, if you're willing, set of comments that takes us to one last position. If you don't mind staying a few minutes more, we can complete Appendix M. Okay, I didn't hear anyone. So the last one is
Judge
qualify.
Pichon, I think I'm sorry, we're on Appendix G. Is that?
No, the last
Oh,
B. I'm sorry,
B.
we're on
I'm
B.
B, I'm sorry.
Yeah, no, thank you. B. I'm sorry. Yes. So the
And
last one.
I'm so sorry. I don't mean to, I just want to make sure that the record's clear what we're doing with path. Is it this path 4? Is that a recommendation from the group that more,
That we developed.
that this group is going to develop and
Well, I have to ask you that question. Is that something we can do ourselves, or do we need to just let the Board of Trustees know that we would like to do that?
Can I help here? So
Yes, absolutely.
I think that if there was the ability of a component of this working group to develop that, and I'm going to put in like a timely fashion, that it could be perhaps brought back to this group, that would be feasible. I think I think it was Mr. Yamshon, and apologies if it wasn't, his point of adding in, others who are more familiar with this space, basically essentially expanding the working group or creating a different working group. I don't know that this is the time to be doing that for this. So I think that if there were some, volunteers who wanted to try and draft something to propose that could be brought back at, I think the next meeting is tentatively scheduled for July. That might be feasible, but I think, bringing more people into this group at this time probably does not make sense. Again, recognizing that this is a huge program, a huge goal, but we are now over 18 months from when we were asked to create a program. And it has many more months to go once it leaves this working group.
Okay, Ms. Doherty, that's a great suggestion. If within this group, a subcommittee can be formed to work while we continue to take the public comments on the other appendixes. Is that what you said, Ms. Doherty?
Yes, that is what I said. And just being mindful that, of availability and
Okay.
yeah.
Judge Pishon, if I may,
Yes.
I didn't mean to imply that the working group should be expanded in any way. I
Oh,
just,
yeah.
we could use some
Expertise. Yes.
education from outside experts. That's all.
Yes. No, as we've done before. Yeah, I understood that.
Thank you.
Okay. May we take the last section? And okay, Mr. Weiner, if you don't mind going to it.
Not sure where.
It's all the way at the bottom. There it
Okay,
is.
qualified mediation related activity.
All right. The comments that we got were regarding the exceeding the 3 hours required. Is that one that was supposed to have been deleted, Mr. Weiner?
Yes, Judge Pashon, this was a
Okay.
relic. This was
Okay.
a leftover, and it was recommended that a commenter caught that this wasn't clear.
Okay. All right.
So I believe that the revision would be to just delete this last
Okay.
clause.
Okay, thank you. So I'll ask for direction from Mr. Weiner and Ms. Mia Ellis. Um, is it now time to take a vote on Appendix B based on the consensus that we've reached?
No.
I think given the discussion about path 4, I think we are not ready to vote on that right now. I think in the interim, our next meeting is July 13th. And so that gives us a good 5 weeks to, I think we've talked about putting together a subgroup, and I think coming back to that meeting to make with some recommendations. That seemed to be the consensus.
Okay, that's fine. And we don't have to rush either since we have quite a few more appendices to take.
Yes.
So if
Yes,
there is a subgroup, it has time to
Yes.
come up with some recommendations.
But I don't think, I guess, given that it is part of Appendix B, is that what
Yes.
we're still in? I don't know if we're prepared to vote on the entire appendix at the moment.
Okay, all right. So we'll just make note of what the consensus has been, and then the last path 4, is referred back to committee.
Yes.
All right.
Time to go.
Okay, so
And
that
I guess to that point, pardon me.
go ahead, Ms. Mia Ellis.
Oh, no, I'm sorry, Judge Pichon, please.
Okay. Well, that will complete our discussion on Appendix B until a subcommittee is formed and they make their recommendation back. And I'm not sure if that will change any of the consensus that this group has made on the rest of the appendix, but we can discuss that at a later time. So I'm going to turn back to staff as to what we will be doing as far as future meetings are concerned.
Well, the next order of our next meeting, July 13th, and we can either see what the subgroup has prepared for path 4 on Appendix B, or we can move forward with the next appendix, which is G, tiers for mediators. But we may, since that's so much overlap with B, we may not be prepared to do that. So
Okay.
we can go forward with the ethical standards for mediators, or we can change up the order and move to the arbitrator or provider organizations.
If I may,
Yes,
my observation would be, with apologies, Ms. Mia Ellis, I think that the overlap between what's been tentatively approved and the tiers requirements, I think there's minimal overlap with this new tier 4. I think it would be feasible to proceed in the order of business that was previously outlined rather than jumping ahead and then jumping back to mediators. My 2 cents.
Okay, so what we can do is just send a memo out to the working group, letting them know what we will be discussing at the next meeting so that they can prepare for it.
Right.
All right, so Ms. Mia Ellis, you said our next meeting is
July 13th.
Okay. Members of the group, thank you so much. This was really hard work and very difficult decisions, and I appreciate all of your comments and your discussion and respecting each other's opinions very much. This is a great group. You've done a wonderful job, and this just wasn't an easy task from the very beginning. So thank you very much for all that you've done. I'll see you again on July 13th. The meeting is adjourned.
Thank you.